For pronouncement of judgment, item number 1 and 2.
The appeals fail and are dismissed as being devoid of merits.
May please, your lordship. Lordship, I'd like to mention item number 49, your lordship. Lordship, actually, the senior is out of station, lordship, in Supreme Court, lordship. Can the matter be fixed next week, lordship, any date, lordship? I take concern from the
Request is made to adjourn the matter on behalf of Senior Counsel Mr. Ken Chaudhary, stating that he is not available today. The other side has no objection. List
I've taken consent from Mizoram.
consent has been taken from the respondents' counsel. List of 4 weeks as for hearing as spread.
Much obliged, Lord.
My lord, with the consent of the other side, I beg to mention item 53. In this, I was supposed to file additional pleadings, lordship. Lordship, the petitioner is now in a precarious position. He's attending to his niece at Bombay. She is serious. So 4 to
Consent
6
for the
weeks.
petitioner, place for it is granted. Further opportunity of 6 weeks to file affidavit.
Grateful, Lord.
Lordship, so another period, lordship, item number 48 also, lordship. I put a appellant, lordship, my friend is for
48, it is that petrol pump matter.
petrol pump metal.
This we are not adjourning. Last date also, we had made it clear that we will not be adjourning it beyond that. He is enjoying the fruits by a stay almost 7 years now. This was a very clear indication in the earlier order. Read.
Lordship, actually, there is a development also, lordship. There is an agreement, lordship. I let the matter reach, lordship. I'll place
All
the
right,
agreement
let the
here.
matter be called out.
Yes,
Yes.
much obliged.
May it please, your lord. No, item number 16, my lord, with the consent of the opposite party, my lord, I beg to, my lord, pay the matter may come up on 25th, my lord.
What is the matter about?
My lord, is a tender matter, my lord, and Mr. Ken Chaudhary, senior counsel, my lord, he is engaged in this matter.
A request is made to adjourn the matter. Violent counsel, Mr. So-and-so representing the petitioners. 63 or 53?
60, my lord,
60.
60, my lord.
The other side has no objection. List after 1 week.
Deeply obliged.
In respect of my lord, item number 51, with the consent of the other side, I'd like to mention it, that it come after 2 weeks, my lord, in a date
Orders matter, let them be called out. These are orders, hearing.
hearing, my lord.
What is the matter about?
Matter with regard to my lord, equivalence issue.
Pay scale, a certain equivalence.
Equivalence issue.
MA Zola, that
Yes.
biotechnology.
Yes, yes.
Mr. Prakash pays for time to prepare and argue the matter. List after 6 weeks.
My lord, may after 2 weeks, the interim order is operating also.
Interim order is operating.
Lots.
List of 2 weeks.
May it please, my lord, in item number 71, my lord,
Hmm.
we have filed one IA for implement, my lord. That has not been filed, listed today, my lord. May I pray, my lord, it is listed on Friday, my lord. Some
All
defect,
the IA.
some defect is there, my lord.
All right, then council, Mr. Barua submits that he has moved an application for implement. The registry to check and list the same if found to be without any defects, subject to removal of defects.
Yes.
List on Friday date 22nd.
Publish.
Daily list.
I've been mentioning for tomorrow, my lord, there's an auction on day after tomorrow. We have filed it today. Some urgency can come up tomorrow.
Writ petition
State petition.
tomorrow.
Public.
Fresh matter.
Yes, fresh.
Daily list for orders, item 52.
Yeah, peaceful lordship, regarding this matter, lordship SLP is pending. before-
Pending, still pending.
Yes,
The SLP pending before Honorable the Supreme Court as reportedly not, has not yet been decided as per MS Bora. Thus, this consideration of this rate of appeal is deferred by 10 weeks, awaiting outcome of the matter pending before Honorable the Supreme Court.
keep it.
Item number 54.
May it please, your lordship. This is with regard to that construction of Silchar Harangaja Road. Lordship, the respondents filed an affidavit on 13/9.
Hmm.
If your lordships kindly come to page 120, running page. The contract was awarded on 16/1/2023, and at present the approximate physical progress is 3.24% in 8-9 months. My lord. I know, my lord, that construction of road, it takes time and there are, but 3% in,
Where is the council? NHI 34. 3% work done, Miss Council. Only,
No, up to that time, that was the last.
that is the last affidavit you have
last
submitted.
activity That was not, my lord. We are undertaking giving by 24, will be completed at that time, that particular moment, up to, we have filed up to. So this-
See, awarded the length is 23
Yes,
kilometers.
my lord.
And you awarded the contract when?
16/1/23.
16/1/23.
My lord.
So 9 months,
Oh,
only 3%.
that
Of-
lordship, that particular period, as lordship was very crucial time. Now it has been working. We have given up to 23/8/2023, up to we have given. Now come work has been full swing, it is going on. By February 24, it will be completed. It is the undertaking. As far as.
Let us wait for some
We'll
time.
wait,
Let's-
Because that
How the
particular
council
period is very
for the
crucial
NHI.
period, my lord.
Submits, Mr. Barua submits that the work on the highway in question, four-laning work on the highway in question is in full swing and is likely to be completed by February 2024.
My lord.
List again on 20th November for receiving the latest progress.
My lord. Obliged.
Highly obliged.
Item number 55.
May I please your lordship? Possibly find the order at page 12, my lord, and operative portion at page 37, para 57.
37.
37, para 57,
Hmm.
the specific direction, my lord. And at page 38, my lord.
Now, the third issue notice to the respondents, steps for service be taken in 3 days whereafter process.
Deeply obliged.
Rule is made returnable in 6 weeks.
Obliged.
Item number 56.
A day's delay.
1 day.
Delay may be condoned, but we'll consider on merits.
Yes, my lord.
All right, delay of 1 day condoned, I allowed. The rate appeal be numbered and listed for admission on 26th.
Item number 57.
Please, your lordship. Your lordship, this IA is for condemnation of delay of 22 days, your lordship.
What do you say, sir? Delay condoned 20 days, rate appeal to be numbered and listed for admission next week.
Obliged.
Item 58.
But this application has been rejected, my lord, on the ground of, without going into the merit of the case, my lord, on the ground.
Why is the court required to go into the merits?
My lord, the petitioner has no fault, my lord. She has submitted within the time.
Yes, she submitted
Within the time.
and then she slept over it.
No, my
That
lord,
means she had no real cause.
that is not the.
Then
fiction.
when did the DLC reject?
My lord, the DLC, my lord, impugned minors was, my lord, 23, impugned minors, my lord, on 17, my lord.
17,
And she
then
has
what were you
submitted in the
doing?
year, my lord, she has submitted in the year 2013 itself after, within the 1 year period after
Mr.
the.
Purkay, the question we have posed is what was she doing after
My
2007?
lord, she repeatedly approached, my lord, but the authority did not provide the copy of the minors, my lord.
Oh. RTI, any application for copying?
My lord, ultimately, my lord, she was provided the copy in the year 2020.
It's very easy to say so. That copy was received after 5 years.
They have kept it, my lord. So my humble submission is there, my lord. Similarly situated cases, honorable single bench in other cases also, my lord, get directed for fresh consideration. And,
Absolutely no, sir. Absolutely no.
my lord, after the dismissal of
Bring
this
out one judgment.
case, I will, well, in other case, similar case, my lord, this honorable court in the
Division bench.
single benches given, my lord.
Single bench's judgment would
In other
not be
cases,
having any even persuasive value on this court.
in similarly situated cases, my lord, in other respects, my lord has given
Come to
direction.
the principles of law.
My lord,
What is the purpose of compassionate appointment?
yes, lord, it's she's till now she is in acute financial hardship, my lord.
That's
And she is, my lord, she is, my lord, without having source of livelihood, my lord. She is,
how she survived for 10 years, tell us.
she is, my lord, doing private tuitions, my lord.
All
private
right.
tuitions
So
that
that
she-
means source of livelihood is there.
No.
Her father's pension would be received.
By mother, my lord.
The terminal benefits must have been received.
Three daughters are there, my lord. And my lord, humble submission is that, my lord, for just for a consideration. And under rule clause 15 of the OM, my lord.
Absolutely no, sir.
Under clause.
Look at your letter at page 50. Do you say anywhere that my application I did not have any information about the rejection of my application? Page 50.
Yes, lordship.
Read.
With reference to subject cited, I have the honor to.
Any indication that I have no idea that my application has been rejected.
My lord, but till today, no positive step has been taken by the authority concerned, for which I along with all the dependents of lesser have been passing the days in most starvation beyond description, my lord.
Yes, yes.
She has no steps have been taken, she has stated, my lord.
Come to the earlier letter, page 49. I have not been appointed on the ground. So that means she has knowledge.
Other persons, those have been appointed, my lord, but her candidature was not taken.
No
but she was-
justification at all.
That was in the year 2022, she has come to know, my lord. And thereafter, she has submitted the application.
No justification. If she was sleeping tight, where is the order rejection, order of rejection?
Order of rejection, my lord, is just impugn, my lord, lack of vacancy. This is the minors, my lord, into page 46. And the OM says, my lord, when there is a lack of vacancy in a particular department, it
Ah,
has
that
to be
OM
taken
we
into
know.
consideration
We know that.
in respect of other department, my lord.
We know about that.
That my humble submission, my lord, it may be given a direction to compare and consider along with
Absolutely
other
no.
department vacancy, my lord.
What do you say, madam?
Lordship, may kindly have a look, page 69, the Honorable Singlet's order, my lord, the last paragraph. Honorable Singlet rightly mentioned all this, my lord, why this case was rejected by this honorable court, my lord.
Dismiss.
I am deeply obliged, my lord.
Okay. Next.
Item number 59.
May I please, your lordship? In this case, my lord, appellant is the National Council for Teacher Education, my lord. And we have against the judgment dated 27/6/2022, my lord, wherein the judgment itself, my lord, is not contrary to our regulations of 2014, my lord.
You are arguing against the very spirit of Assam. Is it not right?
But
What is an
it's-
Assam type bungalow?
It's a pan-India regulation, my lord.
Oh, we are asking you, you are in Northeast.
Yes, my lord.
Herein you can't have flat roofs.
But
The
that-
flat roofs will not last. The purpose of a tin roof is so that the rainwater percolates down. That is the reason. For how many years these kind of roofings have been surviving? Tell us.
that, lordship,
What is the
That's true,
structure?
but-
What is the structure of the new assembly building?
normally.
Pagoda. So your own regulation of 22, the tin roof is allowed.
No,
Did
my
you
lord,
consider that or
in
not?
Our regulation, 22 regulation, my lord, we have already omitted the asbestos, my lord, from our regulation, my lord. Yes, amended. That was amended, my lord. And
Come
I
to
have-
para 27. Para 27. Where is that regulation? Let us see.
Regulation, amended regulation is, my lord, I have.
Let's see. Yes, read.
Regulation 7, my lord.
Number 7.
Yeah, sub-regulation 7, my lord.
Hmm.
Regulation 7 of sub-regulation 7. My lord, got it? At the time of inspection building. At the time of inspection of building,
This is clause.
it's page number 7, my lord. Page number 7, my lord.
Mhm. Yes.
clause 7.
Hmm.
Clause 7, at the time of inspection, the building of the institution shall be complete in the form of a permanent structure on the land possessed by the institution, equipped with all necessary amenities and fulfilling all such requirements as prescribed. The institution shall present the original completion certificate issued by the competent authority, approved building plan in proof of the completion of building, build-up area, and the other documents to the
Hmm.
visiting team at the
Yes.
time of virtual inspection.
So if tell us, Mr. A RCC building having a roof with CI sheet, can it be called a temporary structure?
In fact, my lord, it can be changed, my lord, in any time, my lord. In our view, my lord, and BRC's view also, NCT's view, my lord, it is not a
The
permanent.
Chief Justice Bungalow has survived for 112 years with the
That's
CI
true,
roofing.
But it can be changed, my lord, in any time. In our.
So for that matter, RCC roofing can be changed. The building's elevations are changed, right, left and center. Tell us, your intention is temporary structure.
Yes, my lord.
So whether the RCC building with a tin roofing can be called a temporary structure.
If it is tin roofing, my lord, it can be changed, my lord. So
Whether the
It's not-
structure, structure includes foundations, walls, the floors, stories, everything. Where was the CI that omission of
my
those two
lord,
things?
your lordship may kindly peruse 184 of para 33 of the judgment, my lord. Here it is mentioned that the Black's Law Dictionary, as noted above, has in its definition permanent. Used the expressions fixed, continuing, lasting, stable, enduring, abiding, not subject to change. That is our condition, my lord.
Come to para 27.
Yes, my lord. The building has three numbers of floors, my lord, but in the above, my lord, it's a CI sheet.
So 1500 meters, does it include that top story which is covered by the CI sheet? Tell us that. If excluding that top story, which is covered by a CI sheet, the building has 1500 square meters, where is the question of interference?
My lord, that building is not 1500 square meter, my lord. That is as per their building plan, my lord. Your lordship may.
Let's see the building. Come to para 30.
Page 57, my
Come
lord.
to para 30.
From the
Of the judgment. 30.
30, my lord. That is there, my lord. 1500 square meters, my lord. It is further transferred to total build-up area, which is contained in the building completion certificate duly issued by the Public Works Department and has been annexed as Annex 2 in the affidavit in reply dated 28/1/21, filed by the petitioner is 16,840.225 square feet, which would be equivalent to 1565 square meters approximate. Completion certificate issued by the competent, namely PWD, however, has not been disputed as such. The only objection is with regard to the area under the CI sheet.
Yes.
Exactly, my lord. Since, my lord, they have.
Then the
CI
discussion is at para 32.
It is not disputed that the part of the building has a CI sheet which is apparent from the building completion certificate. Therefore, question would arise is whether a structure covered by CI sheet part C becomes a temporary structure. It may be mentioned that under amended regulation, there is no restrictions on the use of the CI sheets. That's true, my lord. It's in our amended regulation, we have only mentioned that it should not be temporary building.
So how a structure is what is the structure of a building? Is roofing a structure? The structure is the main frame. So main frame is permanent, you don't dispute. Then
Only think about that, my lord, that roofing, my lord, roofing is.
where is
CI
the
sheet, my lord.
restriction that roofing can't be CI? You have excluded that. Consciously excluded CI roofing, which was earlier there. There was earlier prohibition on CI roofing, right?
My lord.
That you have excluded. What is the purpose? Tell us.
I beg to, my lord, page 50.
Where was the earlier regulation? Mr.
Your
Manta?
lordship may kindly peruse the building to completion certificate at page 57, my lord.
Oh, just hold on. Where is the earlier notification wherein there was a prohibition on the CI roofing?
That is, my lord, earlier notification, they have annexed, my lord.
Page,
Page, my lord, page 82, my lord. In our affidavit, my lord, page 82, yes, may appeal, my lord.
In the appeal, can you say
Yes, in appeal, page 82, my lord.
82?
82. Page 82. Clause 7, my lord.
Just. Yes.
Last pen, no temporary structure or
Yes.
asbestos roofing. So, my lord, asbestos roofing is no there. Now, my lord, according to them, my lord, our safe this is Bangalore is the temporary, according to them, my lord. So, my lord, that is can't, my lord. That's why, my lord, their director was asked to travel in Assam, my lord, file a report. He filed a report. Yes, in Assam, that is going on. So, that, my lord, director has been transferred, my lord. This file a affidavit, my lord. My lord, absolutely, this is one of the oldest institution, 33 years running. My lord, That, but, and my lord, very interestingly in Kerala, all are, my lord, I have given photograph in that also, my lord. This is the photograph in, my lord, you will sit kindly see.
Yes, yes.
I have shown to him in the.
That is the concept in areas where there is heavy rainfall. They have to have the slanted roofs. There's no way out because flat roofs, there will be collection of water and it will be seepage into the building. That is the purpose behind it. So you don't expect every building to have a permanent slanted roofing. It's just not possible. Yeah, Assam has been thriving on these structures.
My lord.
So what is the problem with you? And you have excluded this temporary structure or asbestos roofing. You have consciously excluded that. Is it right?
That is excluded, my lord, in our amended regulation, my lord.
Then,
My lord, but so far as building 1500 square meter is concerned, my lord, that building excluding the RCC part is only, my lord, 900 and.
Oh.
CSC part.
so once you exclude this temporary roofing part, then why it would not be included in the built-up area?
As per, my lord, build-up area in our, my lord, appellate order, we have mentioned it at 9806.50 square meter, my lord. That means, my lord,
9806?
Square feet, my lord, that is, my lord, 911.030, my lord, square meter.
Hmm.
So in our appellate order, we have mentioned it, my lord.
Hmm.
And subsequently, our stand is before the single judge is also, my lord, that the build-up area is as short of our regulations.
So built-up
Our-
area, you
Type
say
of
built-up
square
area
meter.
is this much. PWD says built-up area is more than 1500. Now, which fact finding should be considered to be the correct view? And you obviously exclude the area under the roof,
My lord.
which is not permissible. So your decision is wrong on the face of it. Thank you. Dismissed.
Item number 61.
My lord, I could not-
Competition is not welcome.
No, my lord, this I could not, why? Because APSC, I was going, that I have given a top priority.
You're not prepared today.
Top priority. That's why I told my learned friend, it is not, let it come Wednesday. Because some legal issue I have to satisfy. What is my legal right?
Okay. As prayed. Yes.
61 and 62. 62 is the same idea.
Yes, both are same contours.
If it is not inconvenient, next Wednesday, my lord.
Whenever. Next means put 28, 27,
27.
27.
Because I thought that I'll give a priority in APSC matter. Deeply on this.
Item number 63.
But in this case, my lord, the petitioners have challenged the amended ROP rules, my lord.
Issue notice. So and so appear for the respondents. Copies of the writ petition be provided to them. And standing counsel appearing for the respective respondents. Pray for and are granted 6 weeks time to file affidavit in opposition.
Item number 64.
Lordship, today my senior is out of session. Lordship. The
You
matter
are
is-
supposed to be courteous enough to at least inform us.
Lordship,
Let them-
the matter has come because they have not filed the opposition also. In the admission reply not filed column, so maybe the opposite party filed a reply to it, but they have not.
Why, this is a writ appeal, pleadings must have been filed in the writ petition.
Yes, Lord.
Then why do we need pleadings now? Who's there for the respondents? All right, counsel for the petitioners, appellants, praise for time, list after 6 weeks. Pleadings is required to be completed, be. If pleadings are still incomplete, comma, the process be completed by the next date. Who is appearing on behalf of the respondents? Names are not appearing. Check. Smell kiya. Standing counsel. Names of standing counsel. We don't know who's, what is the department? Registrar Cooperative Societies. Who is the cooperative standing counsel, cooperative department? Name of standing counsel, cooperative department. SK Talukdar. Mr. SK Talukdar shall henceforth be reflect in the cause list.
Item number 65.
Please, Lordship. Lordship, 6 week time was given to them to file affidavit, Lordship.
No, you sought time for reply. Last date, you sought time for filing affidavit in reply. Their affidavit is already there.
Yes, Lordship, conducting counsel is in Lake, Lordship.
The petitioner's counsel has petitioner affidavit in reply has not been filed as yet on behalf of the petitioner, deferred by 8 weeks.
Item number 66 and 67.
May I please, Your Lordship?
Hmm.
Lordship, these matters have become infectious, Lordship.
Infectious,
Lordship.
as stated by both counsel for the petitioner, comma, both the PILs are disposed of as having rendered infectious by subsequent events.
Deeply obliged. Obliged, madam.
Item number 68.
May I please, Your Lordship? Well, in this case, well, respondent number 2 has filed an affidavit, madam. We need 2 weeks time for file. Reply, madam.
My lord, I'm appearing for respondent number 4 UGC. The affidavit is ready, it is in transit, it has been sent to Delhi for signatures.
MSP Agarwal appearing for the respondent UGC, prays for further opportunity of 3 weeks to file affidavit on behalf of such respondent. First of all, upon the affidavit being filed, comma, the petitioner's counsel, the matter is deferred by 6 weeks so as to enable parent counsel for the parties to complete the pleadings.
Deeply obliged. All right.
Item number 69.
I paid for 4 weeks time to file every opposition also.
Parent counsel, your good name, please?
DC Bora.
DC Bora, appearing for the response numbers 1 to 6. Praise for and is granted. Further opportunity of 6 weeks to file affidavit in opposition on behalf of such respondents.
Obliged.
Item number 70.
My lord, here I am for the respondent number 1, my lord.
This is a appeal to the revenue, madam. Mr. Borpujari has to be there.
So what to do?
My lord, maybe he's on legs, my lord. I'll inform him, my lord. My lord may defer it or.
What is the matter about?
My lord, petitioner was allowed to cut up 10 lessons of land in 92, my lord.
Hmm.
Since then, my lord, in the year 2004, he developed his that allotted land for the purpose of residential construction. In the meantime,
All
my
right,
lord,
let Mr. Borpuzari come. Pass over.
Item number 72.
Maybe the lordship.
Yes, what is the appeal?
Lordship, here in this case, lordship, the non-payment of Zirat compensation, lordship, is 25. This here, lordship, I am not a recorded patta holder, lordship.
Hmm.
I am a Zirat compensation holder. There is lordship, petitioner his name is Al Zamiatul Islamia Madinatul. Is a institutions, lordship.
Hmm.
Lordship, yes, land belongs to some other persons, and that land has been acquired, lordship. And in my name, petitioner's name, lordship, page 25, a notice has been given that you are interested persons, lordship. And that's why, lordship, a Zirat compensation has been assessed at 14 lakhs 57,000, lordship. And thereafter, lordship, that amount has not been released as because another case was pending and this high court has been granted a stay. And ultimately that writ petition already disposed, lordship, dismissed. And when it came to knowledge in the peasant petitioners that the writ petition was dismissed, then peasant petitioners applied for release that compensation in the year 2000.
Come to para 18 of the impugn order. Come to para 18 of the impugn order.
Lordship, here, this is saying, lordship, enhancement. I'm not.
Not on enhancement. Proper pleadings.
Yes, lordship. Lordship, here, what happened, lordship, in open court, my petition was allowed, lordship, by the single judge, lordship. In open court, lordship, thereafter about 2 years, my petition was dismissed, lordship. About 2 years. As because, lordship, why my petition was dismissed, lordship, I am given explanations, lordship. Thereafter, lordship, after 1 year, the peasant petitioner sent a letter. Then an earlier Chief Justice, lordship. Then letter has been forwarded, lordship, to the concerned judges. And thereafter, lordship, and another IAA has been filed for pronouncement of delivery of judgment. That
Madam, we'll remand the matter back to the learned single judge then. Do you have the order sheets? Get this file of the SB. Get the single bench file. Pass over, Karna. Are we having it right now? Writ petition, record of writ petition. Rest is directed to tag the record of the writ petition number so and so. Original record of the writ petition number so and so with this writ pin and re-notify the matter on Tuesday next, 26th.
Lordship, 27.
27th.
I listen. I listen.
Supplementary list, item 73.
My appeals.
Hmm.
In this case, I have selected the order dated 12/9/2023, passed in a IA, whereby the stay of the my writ petition was was vacated and the writ petition was closed. The facts of this
Writ
case
petition was
closed.
closed.
Yes,
No. Where is the writ petition closed?
because
Only the IA has been closed.
IA and closed and subsequently page 73 in view of the order passed in the IA. Page 73.
What is your writ petition about?
My writ petition, my name was forwarded for the post of president of a school management and development committee.
While the matter was pending.
School Development Committee,
School management. and
MD,
development.
SMDC.
Yes, my lord, SMDC.
Hmm.
While my case is pending, my lord,
Hmm.
before the authority, the resolution number 7, hearing the resolution number 1 was, my lord, appointed by the IS. Golpara, my lord. Then, my lord, I challenge that his appointment, my lord. This honorable court was pleased to, my lord, grant an interim order staying his appointment, that is 1/27/2023.
Hmm.
Subsequently, my lord, the official respondent was appointed as a, my lord, ad hoc president of the SMDC, my lord.
Hmm.
That is the, my lord, Block Limited Education Officer.
What is your right to be appointed?
Because, my lord, my name was forwarded by the, my lord, principal before the, my lord, IS, as per, my lord, the notification dated 24/6/2016,
Hmm.
with consultation of the, my lord, guardians, parents, my lord.
Read the findings in the single bench order.
Yes, my lord. That is, my lord, page 70, page, my lord, paragraph 8.
Yes.
My lord, a reading of the afford extract provisions of the notification dated so and so makes it desirable that the process is to be initiated by the inspector of schools in consultation with the principal headmaster of the school concerned.
Hmm.
And it is not that upon a recommendation being made by the
Principal or headmaster.
headmaster, my lord.
Then
Then, my lord, it
what
would
is the
be-
jurisdiction of the principal to make a recommendation?
because, my lord, as per direction of the IS, my lord, my name was
Oh,
forwarded.
but what jurisdiction does the principal have to make a recommendation? Give us, tell us from the rules, notifications.
Yes, my lord. But, my lord, normally, my lord, in other cases, my lord.
No, no, normally there's nothing. You are in a writ court,
My lord.
or rather now you are in a
Yes,
writ
yes,
appeal.
I
Show us
am-
from law.
I am admitted, my lord, but since my lord, honorable signatures was held that, my lord, my lord, forwarding was illegal, but his appointment also, my lord, illegal.
Whose appointment?
The resolution number 7, my lord.
So you file a quo warranto. File a quo warranto.
My lord, his appointment was set aside, but he was allowed, my lord, since there is an interim order, my lord,
He was.
allowed to function, my lord.
So you file a quo warranto. You don't have any right. Mere recommendation by an unauthorized person, what right can you gain by that?
But, my lord, as per the, my lord, inspector's letter, my lord, my name was forwarded, my lord. So, my lord,
Inspector in consultation with the principal.
yes, my lord.
Whether the forwarding was accordingly, no,
No, my lord.
Then
My name was forwarded.
dismissed. Thank you.
God bless.
ये मैडम को दे दें APSC. Where is the council there? APSC.
Above the list matter, item number 1 to 47.
Yes, Mr. Bishop.
Well, I'll just recap what I submitted the other day. My lord, the appellants have challenged my lord, a judgment and order dated 18/3/2020, passed by the learned single judge, dismissing the writ petition, and the order that was impugned in the writ petition is an order of discharge of the probationer, because all the all the appellants are the probationers. Now, the challenge is basically on two grounds. The first is in case of item number 25, which your lordship is, which I'm arguing.
Sabira Imran.
Now, this is an additional
ground that is taken in her petition, which says, my lord, that she has already completed her probation. And after completion of probation, she was posted as assistant commandant to the 12th Battalion, to 12th Assam Police Battalion by order dated 15/9/2027. I have made my submission on this. And just to recap, my lord, my submission is based on three things. One, after completion of 2 years, there is an order passed by the governor on 15/9/2017, by which it is stated that I'm being posted to the battalion after completing my probation. This is one. The second is that I have been given 2 increments. As per Rule 21 of the APS rule, the first increment is given after completion of 1 year of probation, and the second increment is given after confirmation of the probationer. So second increment was also given to me. And the third point that I have placed before your lordship, that there was I was suspended under Rule 6 because I was in jail for 48 hours. And a disciplinary proceeding was contemplated by the government against me. So on the basis of these things, three things, Melon, I place before your lordship that I'm a confirmed police officer. I have not been a probationer at the time when the order of discharge was passed. So this was my submission in nutshell insofar as.
Mr. Kohli has joined or not? Find out. Just let's check.
Should I proceed or we?
No, you please carry on.
Then
he knows that we'll be taking up the matter.
Yes. He also knows that your lordship made it very clear that no adjournment will be granted, and once your lordship is taking up the matter, we know.
Mr. Mishra, after spending so much of time on a matter,
yes,
if we adjourn it, that is
yes,
not the proper discharge of duties.
Actually, they are using. We have committed colossal fraud. In fact, if it is adjourned, it will be colossal loss of court's time.
My lords, I am here through VC, my lords, on behalf of Mr. Kohli. He will join in some time, my lords. Mr. Mishra may continue his arguments. I am taking notes.
He is continuing his arguments. Yes.
Yes, my lords. Please.
My lord, the second point that I'll place before lordship today will cover everyone across the board. It's a common point in all. And the point is that the order of discharge, though it looks innocuous on the face of it, it is in fact based on the allegation of misconduct. And that has been passed without conducting any inquiry, so much so that it has been passed even without issuing a notice to me. Now, on this point, I'll be making my submission. And my lord, if your lordship will remember, at the back end of my argument on Thursday, I submitted before your lordship that conversation with my lords, in fact, has always helped me. And your lordship told me about Rajasthan judgment. Now I got that judgment, and I'll use it as a sheet anchor at the last of my argument. So I'll use it as a last point to buttress my submission. Now, my lord, on this point also, I made some progress in the last date. Number one, I had placed before your lordship an affidavit in opposition filed by the respondent number 2 and 4, wherein they say that they received a letter from the Superintendent of Police Dibrugarh on 17/6/2017, and that letter perhaps contained we had no access to the letter, but perhaps that letter contains information regarding filing of the first information report and the allegations that have been made. So that was the only thing, my lord, unless because the records, my lord, we have not been shown. And if your lordship has seen the interim order passed by Justice Koteshwar Singh, as his lordship was then, he said what was there in the record. If your lordship can call for the record, then your lordship record of the
State.
yes, so that your lordship may examine how the decision-making process. And
Perhaps when Mr. Kohli starts his argument.
yes,
we'll
I'm sure
start
that they must be having that record. Now, my lord, we have made a statement in paragraph 15 that this order is an order of, in fact, dismissal, not an order of discharge simplicity. And if your lordship remember, I also made it very clear, two things. The probationer, they do not have lien on the post. That means they don't have any right on the post. They are in the same footing as that of temporary employee.
Temporary employees.
So, and even if an inquiry is made behind their back, just to find whether they are suitable for the post or not, then also no inquiry will be required. This is a settled law which I don't dispute. But here, what I have said is that the entire thing is based on a police report. And I also submitted before your lordship that subsection R of section 2 defines what is police report.
Mr. Mishra, we may just a loud thinking kind of thing.
My lord.
But you'll have to make a distinction between inquiry into allegations in service and regarding allegations before entering service.
That
is what the
yes, my lord.
Distinction which has to be.
Yes, my lord, even in Rajasthan case, I'm going to refer it several times, the lordship will not. A notice whether misconduct is prior to the appointment or after the appointment, a notice is signed qua non. And I'll place at least 4 to 5 judgments where the Honorable Supreme Court has distinguished in what cases notice will require to be given and in what cases notice may not be given. I'll place that.
Sure.
Because in Rajasthan case, my lord, Rule 35B, the government has taken a decision and it is inherent in the rule, my lord, to expressly that notice has to be given.
Notice has to be.
So therefore, that's why, my lord, I made my submission that it's a new concept. After going through the Supreme Court judgment, what little I understand, I have come and I'll place that. Now, my lord, when we have said that there is a pleading in paragraph 15 of the writ petition, and I'll place it. This is the pleading which we have taken. That it's by way of, it's a punitive order based on the police report, which contains the allegation that I have bribed my way through. In other words, they are alleging that my appointment is tainted. In reply to that, they have given, my lord, and I will place before your lordship, paragraph 46, 47, 48, 51, 58, 65, 75, and 77. Because they have, my lord, it's an affidavit which consists of 83 paragraphs. And before that, I think 8 or 10 affidavit in oppositions were filed. It all contained 52 pages. This is alone of 35 pages. I have counted literally. So this came after Mr. Kohli came into picture. This entire thing is.
Wiser counsel prevailed, literally.
My lord, my wiser counsel. My lord is the lighter note. This live telecast has become problem for us.
It is a huge
because we go home and tell them, see, I have done this, I have done, and the wife will say, hey, don't lie. If her role, Chief Justice said, it has become a problem for us. Now, my lord, coming to principles of natural justice. My lord, I was reading an article which says, my lord, it is provided in Old Testament that God even followed rather the principles of natural justice and asked Adam and Eve before banishing them from the paradise why they did it, why they ate the fruit. So it's old as the civilization of the or thought, civilized thought goes. Nobody should be condemned unheard. It is also in Kautilya's Artha Shastra, my lord. Chanakya, my lord, your lordship will know. It is also mentioned there about the principles of natural justice. Of course, with the time it has changed. And so what is the, my lord, the present status? For that, my lord, I will submit, my lord, one judgment which I find, which describes which explains the principles of natural justice, according to me, in a very emphatic way. MC Mehta. Your lordship may be aware, MC Mehta, my lord, is it's not, my lord, because
Which
these are
one? MC Mehta, which one?
of course, your lordship.
So many
yes.
MC Mehtas.
But one of those matters, my lord, where principles of natural justice was fine. My lord, I'll rely on 19, 20, and 21 of the judgment. Learned senior counsel for Bharat Petroleum contended that once natural justice was violated, the court was bound to strike down the orders and there was no discretion to refuse relief and no other prejudice need to be proved. It is true that Ridge and Baldwin, it has been held that breach of principles of natural justice is in itself sufficient to grant relief and that no further de facto prejudice need to be shown. It is also true that the said principles have been followed by this court in several cases, but we might point out that this court has not laid down any absolute rule. This is clear from the judgment of O. Chinnappa Reddy in S.L. Kapoor versus Jagmohan after stating, quote, principles of natural justice no exclusionary rule dependent on whether it would have made any difference if the natural justice has been observed. But suppose in a given case, even if natural justice is notice is given and reply is received, it's not going to make any difference. In that case, it can be dispensed to. That's what it says. And that non-observance of the natural justice is itself prejudice to a man, and proof of prejudice independently of proof of denial of natural justice is unnecessary. Justice Chinnappa Reddy also laid down an important qualifications as follows. As we said earlier, where on admitted or indisputed facts, only one conclusion is possible under the law, only one penalty is permissible, the court may not issue its writ to compel the observance of natural justice. Not because it is not necessary to observe natural justice, but because courts do not issue futile writs. It is therefore clear that if on admitted and indisputable factual position, only one conclusion is possible and permissible, the court need not issue a writ merely because there is a violation of the principles of natural justice. Now, whether, my lord, I pause here for a second, whether this is a case of that nature. If the notice was issued, we could have at least shown to them, or at least made an endeavor to show to them that, look, these allegations are not correct. In view of the documents which are there on record, which have been submitted, because by the time it filed, the charge sheet was already submitted. And I have taken the certified copy and placed all the charge sheets before your lordship. My lord, by the way, the volume 1, I have made copies, my lord. This I can keep here, my lord. All the AOs so far filed and all the charge sheets which have been filed together with the remand report, everything is there. Your lordship will find mention of this, my compilation in the judgment itself. It was submitted then. Now, my lord, therefore, I could have shown
Hmm.
that in view of these factual position, these allegations are not correct. And nobody can jump to the conclusion just because there is a police report that the appointment is tainted. We could have at least shown. But that was not done. Now, my lord asked, and they have also raised, they have made a differentiation between two. Misconduct before appointment and misconduct after appointment. Now, my lord, there are series of decisions where in case of mass cheating, in case of mass cheating, where individual innocence will have no meaning. There is mass cheating, mass malpractice, then notice is not required. These are the decisions that I'm going to place before Lordship. My Lord will kindly have this compilation, which I filed in the writ appeal.
Yes. Yes.
My Lord, the first case I'm relying upon is Bihar School Education Board. This is by 3 judges bench, 1971-70, volume 1, SCC 648. This is at page 83 of the compilation, my Lord. 83 of the compilation. I'll rely on paragraph 12 and 13, which my lords will find at page 85. Well, this is not a case of any particular individual who is being charged with adoption of unfair means, but of the conduct of all the examinee, or at least a vast majority of them at a particular center. If it is not a question of charging any one individual with unfair means, but to condemn the examination as ineffective for the purpose it was held, must the board give an opportunity to all the candidates who represent their cases? We think not. It was not necessary for the board to give opportunity to the candidates if the examination as a whole were being cancelled. The board had not charged anyone with adoption of unfair means or mass scale, on a mass scale. In these circumstances, it would be wrong to insist that board must hold a detailed inquiry into the matter and examine each individual case to satisfy itself which of the candidate had not adopted unfair means. The examination as a whole had to go. Reliance was placed upon by Ghanshyam Das Gupta case, to which we referred earlier. The examination result of 3 candidates were cancelled. For this court held that they should have received an opportunity of explaining their misconduct, their conduct. It was also said that even if the inquiry involved large number of persons, the committee should frame a proper regulation for the conduct of such inquiries, but not deny opportunity. We do not think that the case has any application. In the present case, they were talking of that case, my lord. Surely it was not intended where the examination as a whole was vitiated by, say, leak of question paper or by destruction of some of the answer books or the discovery of unfair means practice on a vast scale, that an inquiry would be made, giving a chance to everyone appearing in that examination to have his say. What the court intended to lay down was that if any particular person was to proceeded against, he must have proper chance to defend himself, and this did not obviate the necessity of giving opportunity, even though the number of persons proceeded against was large. The court was then not considering the right of an examining body to cancel its own exam when it was satisfied that examination was not properly conducted, or that in the conduct of examination that these may not be relevant, because what is relevant was if there is a mass cheating, then individual innocence loses its importance. Because even if you give one person says, I have not done it, the examination cannot be, the cancellation cannot be stopped for him. So therefore, in this case, my lord, there are many people who appeared, but we have been chosen without principles of natural justice. And when I come to Punjab case, my lord, Punjab case, my grievances is that only 2 cases have been referred to. The 2 other cases, whereas I refer, and this is there in the compilation of the judgment which I filed before the learned single judge. This started with Amarveer Singh 1. Then in Amarveer Singh, the entire examination was cancelled. No question of any individual notice. Appeal was filed. That was that is reported in Inderpreet Singh Gehlot. Matter was remanded. Give them some opportunity. It's not a case of mass cheating. I'll place with my lordship. The matter went back. Then in Amarveer Singh 2, it is mentioned, a committee of judges were formed. They separated the tainted one from non-tainted one. It is they who separated. I remember my lord asked the question whether they separated the tainted one. Yes, I will show from paragraph 14 of them that they separated. Then also they decided to cancel the whole examination. And by the time the appeal was filed before Joginder Singh in 2014, if I remember correctly, I'll take your lordships through those. My lord, most of the cases were decided. Some were acquitted, some were convicted. And therefore only few of them were there. And my lord, submission was made that those few here, they were there, but they have been acquitted. So at least they should be taken in. The Supreme Court said no. So my lord, acquitted in the Supreme Court, my lord knows. My lord, acquittal, earlier, my lord, in 60s, I have read, there used to be a word, even during British time, honorable acquittal.
Honorable.
My lord, honorable acquittal. Now it is clean acquittal. But acquittal is acquittal. If it is not benefit of doubt, if it is clean acquittal, then it's a different thing. That shows his innocence. But if benefit of doubt is there, then he got that acquittal because of the requirement of proof beyond reasonable doubt. And in the my lord, in the civil cases, my lord knows, including the it's principles, it's beyond rebuttal. Beyond rebuttal. So, my lord, the principle that has been laid down in Bihar case is this: notice is required to be given in case individual is charged. Now, similar, my lord, cases are there, which, my lord,
what you referred is the case of admissions.
I will show selection. I will show selection. This has been considered in Amarveer Singh in paragraph 18. The judgment that I'm placing with your lordship, because from there, there is 3 judges bench, my lord. Joginder Singh and Amarjit, Inderpreet Singh Kohlani are by the 2 judges bench.
Yes.
Now, my lord, one is Krishna Yadav versus State of Haryana. This is a case of employment. My lord will kindly turn to page, it is there in next page only, 87. Yeah. My lord, 87 is the reference says 1994 4 SCC 165, page 87. The relevant is paragraph 40, my lord. Just few lines at page 97, my lord. In the above circumstances, what are we to do? My lord, if your lordship permit me, I think let me place some facts, because that should be. My lord, at page 90, this is regarding appointment of taxation officer in the subordinate selection board. page 90, my lord. The board issued, paragraph 2, I'm pressing. The board issues an advertisement bearing 5 of 86 on so-and-so inviting application for 96 posts for taxation of Inspector Excise and Taxation Department. Out of these 96 posts, 24 were reserved for scheduled caste, 10 for backward classes, and 17 for ex-servicemen of Haryana. The minimum qualification were graduate of a recognized university or equivalent and knowledge of Hindi up to metric level. The selection was to be made on the basis of written test of 250 marks and viva voce test. The candidate will not be eligible unless he obtains 33% marks in each subject and the minimum of 40% in the aggregate. In response to the advertisement, many candidates applied for, and for some reason, the written test could not be conducted. The board again advertised. Then, my lord, your lordship will come to 5. How the selection was. Fictitious roll number were allotted to each candidate in the key book by removing original roll number slip. Thereafter, answer books were sent to different examiners for evaluation. After examination, the answer books were examined. After the examining of the answer books, the examiners were required to prepare an award list, which is summary indicating the fictitious roll number of a
That's called
candidate.
coding. That's coding basically.
My lord,
It's a coding and decoding.
Yes, my lord. Yes.
Yes.
And the mark obtained by them in each subject. On receipt of the answer book, the mark obtained by the candidate in each subject were entered in the key book. On the basis of key book award list and answer book, the results of the written test was prepared by the board. Thereafter, the same was published for displaying on the notice board. Any candidate who desired to get his answers book rechecked could do so within a period of 30 days from the declaration of results of the written test only after depositing the prescribed fee. Such procedure was indicated in the rules. This was also practice prevalent in the board. However, strangely, the interview were directed to take place on 30/10/89, and after expiry of only 17 days, the interviews were held in 3 different centers, Hisar, Karnal, Pinjore. Therefore, 3 interview committees had to be constituted. Each committee consisted of 2 board members, 1 advisor of the Excise and Taxation Department. The interview went on till 12/10/89, and about 200 candidates were to be interviewed by each committee on each day. The appellants claim that their performance in the interview were excellent. Therefore, if judged on the basis of the written test and performance of the interview, they ought to have been selected on the basis of merit. Originally, respondent number 4, Anand Singh Dengi, was the chairman of the board. He resigned. After his resignation, the new chairman in his place was appointed by the state government. After appointment of the new chairman, on the next day, selection list for the post in questions was finalized. The list was sent to department secretly. This was clear violation of the norms and requires publication of the notice board, so that it could be made known to the public. The selection list was kept highly secret document. The same was sent to the second respondent by hand. Appointment letters were issued by calling selected candidates. Joining reports from all the selected candidates were obtained in Chandigarh on the spot. Some of them were shown to have joined the respective place of posting. No medical examination for selection of candidates were conducted, nor were their antecedents got verified before actual appointment. This will clearly establish that favoritism, nepotism, unfairness, and good deal of political influence played a vital role in selection of disregarding merit altogether. For reasons best known, the original records, including the answer sheets, were destroyed on 17/12/89. This is attacked by the respondent as an attempt to cover up the illegalities committed by the board. The examinee could ask for recheck, evaluate their answers.
Before that period was over, the interviews were.
Yes, immediately they destroyed. Primary on these allegations, several writ petitions were filed before the High Court of Punjab and Haryana. The facts as obtained in WPC so-and-so were taken into consideration. The High Court was of the opinion that in view of the fact that all answer sheets and tabulation sheets have been destroyed, the allegation of the petitioner therein could not be asserted. award of 100 marks for Viva Voce would work out to 28.5% of 250 marks. This was not excessive. Ultimately, a direction was given not to fill the post beyond the advertised number of 96 posts. The other writ petitioner came to be dismissed, applying the ratio of this judgment. Aggrieved, then they went to the Supreme Court. In view of the serious allegation made particular of the destruction of record alleged to be for want of a space, this court passed orders on 9/10/1991 directing the government of Haryana to refer the matter to CBI for investigation and complete investigation within 3 months. The time of completion of investigation was extended. The Superintendent of Police, SP, CBI, Chandigarh has filed detailed report. We record the same. Then it was recorded. And should I continue to place these facts, or I can simply say that on the basis of CBI inquiry, everything was cancelled. I remember, my lord, when Mr. Kamal Chaudhary was arguing, your lordship pointed out there was a CBI inquiry. I don't know whether this was the case or the other case. But here, let me place it, my lord. The argument on behalf of the appellant addressed by the learned counsel Sri so-and-so may be summarized thus. This is a clear case where various acts of nepotism, favoritism have been committed. The whole selection is arbitrary. Very conveniently, destruction of record is pleaded. Unfortunately, the High Court has not given much attention to the allegations and examined the veracity of these allegations. When the respondent sought to cover under destruction records, that plea had come to be accepted. As a result, the appellant's allegations could not be verified. This is hardly way to render justice. Fortunately, before us, there is a report of CBI. This will clearly establish how there is concerted fraud. Persons in authority have played Tron with the fate of many candidates. There are overwritings and interpolation in the selection list. Person who did not attain the interview have been awarded marks. Forgery have been committed. There are several cases where person who took the Viva Voce have been declared absent in the final selection list. Political influence has a free hand. Hence, the entire selection will have to be set aside. So here, the entire selection was set aside by the court, my lord, on the basis of CBI inquiry. And then, my lord, the ultimate paragraph, which I wanted to submit for my purpose, 20 at page 97. In the above circumstances, what we to do? The only proper course open to us is to set aside the entire selection. The plea was made that innocent candidates should not be penalized for misdeed of others. We are unable to accept this argument. When the entire selection is stinking, conceived in fraud, delivered in deceit, individual innocence has no place as fraud unravels everything. To put it in other words, the entire selection is arbitrary. It is that which is faulted, not the individual candidates. Accordingly, we set aside the selection of taxation inspectors. My lord, the takeaway law laid down is that when the entire selection is stinking in fraud, individual innocence has no place. Therefore, no notice can be given. And this is the case where your lordship has seen. This has happened prior to their appointment, these selections, like in our case. Now, if, assuming for a second, the entire selection was cancelled, this APS and ACS, perhaps in view of these decisions of the Supreme Court, we would not have been before your lordship. We could not.
No, we can't guarantee that.
My lord?
No one can guarantee that.
Correct. No. No, even if, my lord, suppose before I know, I cannot say, but I'm sure before your lordship, if anybody says this, your lordship will follow that, or you're trying to teach me law. This I've never. So this is the, my lord, principle of law.
We are here to learn law, Mr.
My lord.
There's no doubt in our mind. Every day is a learning process.
That's, my lord, I had been saying. Sometime, my lord, when I say your lordships get irritated, your lordships say, oh, I keep learning. But the fact is that, my lord, I personally believe that the day I say that I know, that's the end.
That's the end.
That's the end. So,
And the
therefore,
best thing which I personally have learned is patience.
my lord. Yes.
Probably, after coming to God, it probably, these are the one you argued earlier and a few others, wherein the hearing, there was only one case in Rajasthan, wherein the hearing continued to another day. That was the death reference case. 4 persons were sentenced to death. Therein we heard the matter very patiently,
My lord,
allowed them
everything-
ample time.
Everything is there perhaps, and there will only be few things to say.
So,
I believe,
so that is the best thing which
my lord,
I personally have learned is to be patient,
yes, my lord, because patience is
which was never my virtue.
Patience is the key, my lord. Patience is the key. My lord, I remember I was arguing a matter before the bench of Chief Justice Chalmeshwar and Amitav Roy, the division bench. And to oppose me, Mr. Banerjee had come. He was then Additional Solicitor General. And he waited for 5 days. And Justice Chalmeshwar told him, I'll not grant adjournment. Then he replied hurriedly on Monday, and Tuesday he left. Tuesday I replied. So it happens, my lord, in some cases.
That's quite okay.
Especially when the settled law is unsettled. This is what happens. My lord, the third case, similar point, is Ocha, and this, my lord, my lord, the learned single judge referred to these, and I will show, my lord, where he has referred. The second case, this is also referred by the learned single judge, O Chakradhar, my lord, 2002, 3 SCC 146 at page 111 of my compilations. Eight and 12, no? 8 and 12. I'll state, my lord, factors similar, mass cheating or mass manipulation. If my lords will kindly turn to page 116, my lord. Paragraph 8.
Your argument is that in cases of mass cheating,
yes,
there is no requirement to adhere to the principles of practice of justice. So,
my lord,
no dispute about that proposition. Yes.
Paragraph 8, if my lord will kindly say 116.
Yes.
In our view, the nature and extent of litigation and irregularities committed in conducting a selection will have to be scrutinized in each case so as to come to conclusion about future course of action to be adopted in the matter. If the mischief played is so widespread and all pervasive, affecting the result so as to make it difficult to pick out the persons who have been unlawfully benefited or wrongfully deprived of their selection, in such cases, it will neither be possible nor necessary to issue individual show cause notice to each selectee. The only way out is to cancel the whole selection. Motive behind irregularities committed has also had its relevance. Then, my lord, few lines from paragraph 12 at page 117.
Yes.
My lord, last 2 lines. We are therefore of the view that it is not, my lord, got it. We are therefore of the view that it is not one of those cases where it may have been possible to issue an individual notice of misconduct to each selectee and seek explanation in regard to large-scale, widespread and pervasive illegalities and irregularities committed by those who conducted the selections, which may, of course, possibly be for the benefit of those who have been selected, but there may be few who may have deserved selection otherwise. But it will be difficult to separate the cases of some candidates from the rest, even if they may have some. The decision in case of Krishna Yadav applies to the fact of the present case, and the appeal therefore deserves to be allowed. My lord, these 2 decisions have been referred by the learned single judge for the purpose that the learned counsels appearing for the writ petitioners could not show any decision which shows that the police report cannot be acted upon. Never our case. That is never our case. Why police report cannot be acted?
No, that was the argument of Mr. Chaudhary.
I'm-
The fervent argument was,
Yes, I heard that, but my lord, with all respect to him, your lordship, that day itself, your lordship pointed out that what is CBI inquiry? So what I'm saying, my lord, suppose there is no police report. Otherwise, also the government receives some authentic information.
authentic information. That is what the,
Why
thing
it
is that
cannot be acted upon?
authentic information, should-
Yes,
which is fit to be relied upon.
yes.
Yes.
So in case on that basis, they decide to cancel the entire examination, then your lordship will decide whether it was decision was correct or not. No question of any individual notice will come in.
Precisely, precisely.
So, my lord, that portion of the single judge order I will show when I go to the paragraphs, otherwise there will be repetition. My lord, there are similarly cases which I don't want to, my lord, I'll just give passing reference. My lord, a 3 judges bench. My lord, the cost of repetition, I'm saying Joginder Singh as well as Inderpreet Singh to Alana are by 2 judges bench. My lord, the next case is Viswaranjan Sahu, 1996 5 SCC 365. 365. Just one paragraph at page 105. 105 of the compilation, this kind of compilation.
Yes.
Paragraph 3, by not just 10, 15 lines, I'll place it. 107. A perusal thereof would indicate the enormity of malpractices in the selection process. The question, therefore, is whether the principles of natural justice is required to be followed by issuing notice to the selected person and hearing them. Is it true, as contended by Mr. So-and-so, the learned senior counsel appearing for the petitioner, that in case of selection of individual, his selection is not found correct in accordance with law, necessary a notice is required to be issued, an opportunity be given. In cases like mass malpractice, as noted by the tribunal, as extracted herein before, the question emerges whether the notice was required to be issued to person affected, whether they need to be heard. Nothing would become fruitful by issuing notice. Fabrication would obviously either be known or no one would have come forward to bear the brunt. Under these circumstances, tribunal will right in not issuing notice to the persons who are said to have been selected and given selection and appointment in the procedure appointed in flagrant breach of rules offending Article 14 and 16 of the Constitution. My lord, it is said when the grain cannot be separated from the chaff, it has to be cancelled. Then the next case is Hanuman Prasad, my lord, at page 108. Just one paragraph. Now, this is, my lord, his lordship's summed up here, the case of malpractice before appointment. The relevant paragraph 4, my lords, will get at page 110, man.
Yes, please.
It is then contended that though the selected candidates have no vested right, they had got legitimate expectation for appointment when they were selected for being appointed. They should be given prior opportunity and also know the reason for cancellation. In support of his contention, he placed reliance on paragraph 8 of this court's judgment in Asha Kaul versus State of J&K. It is unexceptionable that when duly constituted selection committee makes recommendation for appointment of selected candidates, the candidates do not get any vested right or legitimate expectation unless they are appointed according to the rules. They have a chance to be appointed as they have been selected by the recruitment agency. In that case, the government has cancelled the select list without any reason. This court has laid the above rule in that background. The ratio therein has no application for the regions that after perusal of the report submitted by the investigating agency, the competent authority has cancelled the selection so that a regular and proper examination could be
So, Mr.
conducted.
We will read all judgments you cite. But please try to see that these cases which you are referring are cases of copying in examinations. Herein the facts are different. Herein the answer books were substituted. That is the finding. So mass copying,
So no,
how do these judgments apply to?
I will say, madam, mass copying, your lordship will just hold it for a second.
Because you have
The next-
cited 4 judgments on the same
No,
principle.
no, the next line, your lordship will see.
Yes.
The competent authority has cancelled the selection so that regular and proper examination could be conducted, giving opportunity to everyone in a fair manner. No prior opportunity need to be given in case of mass copying.
Yes.
Yes, it is not a case where name of candidate committed copying. Accordingly, we do not find any illegality. Your lordship, I have just placed one decision prior to this, where, my lord, the entire records were destroyed. The answer scripts were destroyed.
So it is not, the case at hand is not such a case. Therein
My lord,
material is
my lord,
there.
if
That material, you will have to cite judgments in light of the facts which prevail. These
My
are
lord-
general principles. In mass copying, no notice required. All right, agreed.
yes, but
Herein we have a
therefore,
case.
my lord,
You will be arguing on the issue that the state has drawn distinction between, they have retained some candidates and chosen the appellants herein.
my lord,
In what circumstances?
when I go to the, my lord, Punjab case, they say it's not a case of mass copy. In Punjab case,
This is not a case of copying at all.
that's right.
The
So
case at
even-
hand is not a
even
case of
there,
copying. It is a
if-
case of answer sheets being substituted
my
at
lord,
a subsequent point of time.
my lord, that is just an allegation. There's just an allegation, and only few candidates have been picked up. Now, rule of natural justice, my lord, will have to be applied in this case because mere allegation without hearing the few candidates that they have segregated, my lord, for punishment. Few candidates, the others have not been. I have no grievances against that. But the question is, if there is an allegation, and the allegation is particularly upon the candidates who are identifiable.
That we understand. When the identified persons are being picked out
Yes,
for action of removal from service,
yes,
then as per you, the principles of natural justice come into play.
Yes.
That's your argument. We will take note of that.
Yes.
But these cases of mass copying,
Learned Sigma judge in paragraph,
mass copying cases have no application in the present context.
if, my lord, such micro analysis is going to be made, then, my lord, verbatim facts may not be available.
It will never be,
Verbatim fact
never
may
be.
not.
It's a
Because
well-settled
all-
principle, cardinal principle.
all
No
that
two
I'm-
cases are same on facts.
Correct. So all that I'm trying to say, that if there is an allegation against identifiable persons, whatever may be, whether it is individual case of mass cheating or individual case, my lord, where the allegation is that the marks have been changed. Similar allegations which were there, my lord, in other cases which I have placed, Haryana case, my lord, that is Krishna Yadav case. Similar allegations were there. And the chairman named, and why, my lord, go to this Punjab case? Punjab case, my lord, Ravinder Pal Singh Sidhu was the chairman during 1996 and 2002. And, my lord, he usurped the power of the commission to the exclusion of all the members. And he has made appointment, and there were approvers. Here also there are approvers. There are 3 approvers here. Accused number 69, 70, and 71. And they don't say anything about us. They say about the chairman. And what surprises me, my lord, that they have not only been given pardon, They are continuing in service. And I have brought this, it's in written argument which I submitted before the learned single judge. And the other day, my Lord Chief Justice, you were talking about the Wipro B.K. Sharma's commission. Your Lordship is correct. Your Lordship has correctly seen the newspaper. And the newspaper report says that the first report has already come out, where His Lordship, my Lord, has identified 37 persons, candidates. And the newspaper report says the second likely to identify 12 or 14. No action has been taken. Your Lordship will kindly take my written argument. Lord, what I'm saying is that the appellant whom I represent, they had a bright career, my Lord, the career as a student, and they have been picked up. And I'm just trying to show, my Lord, what has happened in this case. Your Lordship will kindly turn to page 15 of my. Okay, second copy I sent me.
No, we'll share, don't worry.
Yeah,
We'll
I
read
have
together.
copy.
We'll read together, don't worry. Page 15.
Oh, so madam, page 15.
Yes.
I have written in bold this thing on approvals in this case. In the instant case, 3 candidates were also appointed to Assam Civil Service and Assam Police Services, namely so-and-so, so-and-so, and so-and-so. Became approvers. They were not only given pardon under Section 306 of the Criminal Procedure Code, but also their services were not terminated. However, these approvals evidence will not be relevant in the case of petitioner. It will be relevant only for the officials of the UPSC. So, my Lord, this is how we have been treated. So, my Lord, if the point that they are taking, they're trying to make a distinction between pre-appointment and post-appointment. On the mere allegation, I'm saying, even if, my Lord, for a second, 311 is not required. Your notice is required. Rajasthan case, your Lordship has seen. The person, my Lord, who was appointed in a government service, I will just, your Lordship may recall it. The person was appointed as a teacher in a government service, in a government school. He submitted a forged and fabricated B.Ed certificate. On that basis, he was given appointment and he was confirmed. After his confirmation, my Lord, when he has submitted, naturally it is sent for verification. That was from Jaunpur University, Purvanchal University, Jaunpur, UP. When, my Lord, the director wrote them, the university authority replied saying that we have not issued any such certificate, these are forced. Notice was issued. Notice was issued, but, my Lord, he did not reply. Because a charge sheet was also, FIR was also lost. And after he approached the court after he was acquitted from the court in 2007, which was decided by my Lord, Mr. Chief Justice in 2008. So even there, my Lord, the principles of natural justice was followed.
Yes, right.
And nobody should be condemned unheard.
We'll take note. But what we are trying to say is that cases of mass cheating would not be very relevant in the present.
My Lord, when I come to Punjab case, perhaps I'll be able to. But, my Lord, your Lordship may see Palak Modi, this case was referred earlier. Palak Modi's case, my Lord. Palak Modi, my Lord, will get in my compilation
261.
at page 261. Here is a case where there's a case of probationer. And he continued to be on probation when he was to appear in an examination for confirmation. I'll place paragraph 1. whether at page 265, my lords, whether the alleged use of unfair means by Palak Modi and Prabhat Dikshit in the test held by appellant number 1, State Bank of India, constituted foundation of the decision by the General Manager, State Bank of India, Human Resource Department to terminate their services. The State Bank of India officers is a pivotal question which arises for consideration in these appeals filed against the order dated 17/1/2011 passed by Allahabad High Court in so-and-so case. Then in response to advertisement issued by the appellant number 1, which was published in 1/7/2008, private respondents applied for appointment as probationary officer. They appeared in two-tier examination held by the bank, which was followed by a group discussion and interview. On being declared selected, he was selected. Then, my lord, 3, while later dated so-and-so, the Deputy Managing Director, Corporate Development Officer of the bank, the probationary officers banks were informed that they are due for confirmation on so-and-so date, and therefore they may appear in the test proposed to be conducted on so-and-so. Paragraph 2 of the letter, which has bearing on the decisions in these appeals are under. And then, my lord, about policy of confirmation, your lordship will come to, for the ratio, my lord, your lordship may come to page 25. Para 25, page 278. Para 25, my lord, 278. The ratio of the above noted judgment is that a probationer has no right to hold the post. His service can be terminated at any time during or at the end of the probation on account of general unsuitability for the post held by him. If the competent authority holds an inquiry for judging the suitability of the probationer or for his further continuance in service or confirmation, such inquiry is the basis for taking decision to terminate his service, then the action of the competent authority cannot be castigated as punitive. However, the allegation of misconduct constitutes the foundation of the action. The ultimate decision taken by the competent authority can be nullified on the ground of violation of principles of natural justice. We shall now consider whether termination of the service of the private respondent is vitiated due to violation of the rules of natural justice. But then they ultimately find that yes, it was. And then the Supreme Court intervened. Now here also they are saying it's a misconduct on our part. So we did this, we bribed our way through. All these allegations are there. And because we have bribed, there was interpolation and the answer script was changed. My lord, I can say that if an opportunity was given to me, that look, your answer scripts have been replaced. And the ground is because these are not printed in the government press. I would have straightway taken through the tender notice issued by printing and stationery department of the government. But they outsource the printing. Government press does not print. And what surprises me is they have obtained FSL report. And they say this is not printed. You have to send both the copies where it is printed, the original one and the duplicate one, according to you. I would have said this. Then, my lord, on recovery of the answer scripts on the basis of extrajudicial confession, I would have said, even if you consider is section 27 recovery, the first question that I asked, where the answer scripts will be kept in APSC? In the examination branch, which is the confidential section. So they are making out a case that on the disclosure by so-and-so, we went and the open and it was there. It will be there. Where it will be. Finally, my lord, I can predict, my lord, it will meet the same fate as Mohit Hojai, this case. It's likely, but then we will be finished. our career will be finished without adhering to the principles of natural justice. Well, virtually, this is the last forum, I can say. This is the last forum. They cannot go further. They don't have means, they don't have anything, they cannot. Therefore, my lord, now paragraph, the ultimate para, my lord, I'll come to paragraph 51. They set aside the termination order and they directed, the appellants are directed to reinstate the respondent number 1 within 15 days of the production of the copy before so-and-so, and give her all consequential benefit. Now, this, because, my lord, they were cornered. These points were not taken in the earlier 8 or 10 affidavit in opposition. But thanks to Mr. Kohli, his ingenious mind brought this pre-recruitment and post-recruitment. But fact remains. Fact remains. Therefore, my submission would be that they have really been, my lord, they have really been made to suffer without adhering to without giving them any opportunity to explain. And my lord, so far as mass cheating is concerned, it is not only mass cheating, it could be mass misconduct. Yes. Mass misconduct, case of mass misconduct, they have bribed the chairman and appointed. That's a misconduct, that's not mass cheating. So there also no opportunity should be given because everybody has paid money to Mr. Chairman. So it's not only mass cheating, the principle of law which has been laid down is that principles of natural justice will have to be followed where the grain can be separated from the chaff. That is the principle which has been laid down. Now, my lord, your lordship may come to the paragraphs of the, as I'm arguing, my lord, I'll place the paragraphs here. I don't want the repetition. Your lordship will kindly have paragraph 48. The paper book in item number 25.
We'll read from the original.
Well, say that is the paper book. In fact, I have
Paragraph.
Paragraph by lord 47. Internal page quota say 88 below.
Yes.
Internal page 88. No, but this has been paginated. No? Original page was there.
Why not para 46, Mr. Mishra? Read
I-
para 46.
Yes, I think I meant 46, the Palak Modi's case. Clearly, the allegations of irregularities on the part of the petitioner are not allegations of any irregularity, negligence, inefficiency, misconduct taking place during discharge of their duties, post-recruitment, or after having been appointed to public offices. The allegation against the petitioner in indulging in crossing irregularities or fraud involving payment of illegal gratification for securing appointment to public offices are apparently pre-recruitment period. There is before, that is before they were appointed to public office. In understanding of this court, the element of misconduct which reverberate the submissions made on behalf of the petitioner is attributable only in respect of periods subsequent to the valid initiation. Now, your lordship will see this. This is what I was saying. Not a single citation could be placed on behalf of the petitioner for the proposition that irregularity is committed during the recruitment process and or appointment had been made and or before a person is born in the cadre who would conduct misconduct. A veiled attempt has been made when their reliance was placed in paragraph 37 of the Palak Modi to say that the use of unfair means in evaluation of the test or confirmation test which constitute misconduct. The reliance also placed vis-a-vis facts and circumstances in the present case is altogether out of context. Palak Modi in the private respondents therein had already been appointed as probationary officer way back in 2006. In due course, State Bank of India informed them that they were due to confirmation in service, and therefore they are to appear in the test proposed to be conducted on 7/2/2011. The private respondent appeared in the test held on so-and-so, but their names did not figure in the result declared on so-and-so, primarily on the ground that Institute of Banking and Personal Selections, the body, was entrusted with the task of preparing the examination paper and evaluating answer sheets, submitting the report to the bank that for some candidate, including the private respondents, were suspected to have used unfair means. Thus, Palak Modi, which makes a mention of unfair means during evaluation confirmation test, would constitute a misconduct, was only in respect of tests conducted for the purpose of confirmation in service. No law was laid down in Palak Modi that misconduct can also be stretched back to the period prior to entering into the service, and illegality is committed during the selection process, as misconduct cannot be pre-recruitment phenomenon. The very bedrock of the submissions made on behalf of the petitioner, that the impugn action being founded on misconduct, therefore principles of natural justice and or provision of Article 311 Constitution could not have been dispensed with in the considered opinion of the court, does not hold any water. So again, the distinction is made on the same thing as I've been repeatedly saying, pre-recruitment and post-recruitment. My lord, the principles of natural justice applies across the board. It is nobody should be condemned unheard, and it will not depend on the facts of the case, in which case it will be given, in which case it should not be given. The only difference that will be made is, even if you issue show cause notice, what you are going to get in case of, say, there is mass misconduct, where the entire selection process is cancelled, then it will come. Not otherwise. It cannot be, my lord, it cannot be, my lord, reduced. Its application cannot be reduced to a particular situation, that only if it is post-appointment, it will apply, otherwise it will not apply. My lord, I remember, my lord, I don't know if your lordship, I'll take your lordship's permission to say how principles of natural justice used to be applied during Saddam Hussein regime in Iraq. There was a saying goes, Mr. Kohli will be acquainted with it. Malak Saddam Hussein's daughter wanted a particular professor of her college to come and teach her at home. So he requested her father to do. His father, as usual, he asked one of his generals, go and get him. After a week or so, the daughter asked. He said, I had asked him. So he called that general. Where is that professor? He said, sir, we called him. He confessed and we executed him. So the principles of natural justice will not apply there. So unless they want to execute us like that, they've already executed us. My lord, I am just giving one example. Suppose out of these 20, 30, I don't know how many. If, my lord, let me narrow it down. If suppose it is, the allegation is leveled against two persons, they'll be thrown out like that without application of principles of natural justice, because this is committed before, the allegation is before they are appointed. My lord, here the moment a person is appointed, he becomes a member of the service. Your lordship will kindly have this only, my lord, this compilation only at page 1. At page 1. Kindly see the definition, rule 2, member of service. A person recruited to the service after commencement of these rules. So we were recruited after commencement of these rules. We are a member. Rule doesn't make any difference between a probationer and a permanent employee. We are a member of the service.
Clause 3 is the applicable clause to the petitioners.
My lord?
Clause 3 would apply to the petitioners. All right, this is before commencement.
My lord, only one. That first will apply.
Okay.
And they are the member of the service. And a member of the service You cannot make a distinction, such fine distinction. No, you were, I have not come across any decision as learned single judge said we could not produce. Well, not one reply that I could have given if Honorable Single Judge had asked me that you have not produced a single judge to show this, I would have said, my lord, sun rises from the east, can I support it with some ruling? So this is the case, my lord. Without giving, my lord, adhering to the principles of natural justice, these people have been, my lord, condemned. Now I'll come to my lord, Punjab case. Learned Single Judge has referred Punjab case in paragraph 49. I'll come to that after placing that. Wherein he refers only Inderpreet Singh, Kahlon, and Joginder Singh. I'll just please.
You want to take a break? You can go.
No.
If you want to take a break, you can continue later.
I'll continue as long as I can. My lord, my throat gets parched. Now, my lord,
You can ask Mr. Das to read the judgments.
I'll allow that I'm not reading the judgment. Just few paragraphs. My lord, I'll not place the whole judgment.
Yes.
Just few paragraphs. My lord, what is important is the date of decision in Amarbeer Singh 1 that I will place. This is the first case.
119.
Page 119, my lord, of my compilation. 119. Now, the distinction which I will say from this case, it's a different thing that ultimately the Supreme Court, Honorable Supreme Court interfered and he said they the non-tendered, you reinstate them. And government also agreed. My lord, your lordship may kindly turn to page 132.
Hmm.
132. No, this one, paragraph 18.
O Chakra.
Paragraph 18 starts with 132.
That is O Chakra that has been reproduced.
Yes, yes. Now, no, what I want to show you, your lordship, is this. Page 140. Page 140. Just above paragraph 19, last 3 lines of the paragraph. The state government was therefore justified in cancelling selection in its entirety. No fault can be found with this decision in regard because these circumstances, grain could not have been separated from chaff. The meritorious candidate has also to suffer. Because the question was raised here about principles of natural justice. And that Bihar education case and all cases have been considered in this paragraph, my lord, paragraph 18 only. It's a long paragraph. All cases have been considered and then they distinguished it because it's a large scale thing and therefore we will cancel it. And the whole thing was cancelled by the government. Now, my lord, as against this, an appeal was filed in the Supreme Court. That was, my lord, reported, and the name of the case was Inderpreet Singh Kahlon at page 144. 144. My lord, if the bottom of page 144, my lord, will see from the judgment and order dated 7/7/2003. This is the judgment of Amarbeer. And I can show, my lord, few writ petitions, number 2, just to show that this is Amarbeer's case.
There is no issue about that. No one will dispute this submission.
Because the numbers are matching. Now, this decision, again, my lord, will kindly note down the date. This decision was given on 3rd May 2006. 2006. I'll place, my lord, 3 paragraphs from here. There are paragraph, my lord, 93, 94, and 95. At page 188, my lord.
Yes.
I'm placing paragraph 93. We must, however, express our satisfaction that no candidate for the year 2001 has been appointed. My lord, I remember to have seen the bank locker. It was shown on the television of the Mr. Ravinder Pal Sidhu. 2-3 bank, it was full of cash, full of cash. We must, however, express our satisfaction that no candidate for the year 2001 has been appointed. His tenure was 96 to 2002. So 2001, nobody was appointed. It is one thing to say that having regard to the nature of selection process, no person appointed from select list, as no person has right to be appointed only because his name appears in the select list. But in our opinion, a different standard must be adopted for termination of service of the officers who have completed about 3 years of service, some of whom, as noticed, passed departmental test, some have been given higher responsibility. They have completed period of probation, some were nearing completion thereof. They presumably have been working to the satisfaction of the authority concerned. Same thing, my lord. We were continuing to the satisfaction. That is how, my lord, your lordship has seen order dated 15/9/2017 says that I have completed and then I have been posted to the battalion. Now, paragraph 94. The impugned judgment has also the order of the state government and the High Court, thus liable to be set aside. And directions are issued. Although impugned judgment cannot be sustained, lordship will kindly see, we are of the opinion that interest of justice would be served if the matter are remitted to the High Court for consideration of the matter afresh. However, with a view to segregate the tented from non-tented, and that in the interest of justice, the High Court should be requested to constitute 2 independent scrutiny committees, one relating to executive officer and the other judicial officer. Some sort of principles of natural justice were applied in view of the facts of this case. We would furthermore request the High Court to consider the desirability of delineating the area which would fall for consideration by such committee within time frame. Copies of such report of the committee should be supplied to the learned counsel for the petitioner. This is one facet, my lord, of principles of natural justice. And or at least they should be given inspection thereof. The parties shall be given opportunity to inspect any document, including answer sheets, etc., if an application in that behalf is filed. Such inspection shall, however, be permitted to be made only in presence of an officer of the court. The appellant shall be given 2 weeks' time only for submitting their objection to such report and their comments, if any, on any material whereupon the High Court places reliance from the date of supply of copies or inspection is given. Having regard to the fact that the appellants are out of job for a long time, we would request the High Court to consider the desirability of disposing the matter expeditiously as possible, preferably within a period of 3 months from the date of receipt of the copy of this order before parting. With the case, however, we may observe that it is expected that the state, having regard to the magnitude of the matter, shall leave no stone unturned to bring the guilty to book. It is the duty of the state to unearth the scam, spare no officer howsoever high he may be. We expect the state to make a thorough investigation into the matter. These appeals are allowed to be so-and-so, so-and-so. There is a majority judgment. Now, your lordship has seen this is a case of corruption, reporting, so many, like Haryana case, where political interference was writ large, yet principles of natural justice was followed. But after this, the matter went to the High Court. And after doing whatever the Supreme Court had directed, That conclusion was same as was in Amarbir Singh 1. They said, cancel all the, we cancel. So it was all cancelled and placed, because placing my lord, 1 or 2 decisions will not do. Therefore, I decided that all cases will be brought to my lord's notice. My lord, your lordship will kindly come to I'm calling it Amarbir Singh 2. At page 208 of the compilation.
Yes.
My lord, paragraph 3, after the remand, the Honorable High Court Punjab, my lord, constituted 3-member committee who considered the matter and submitted their report. My lord will kindly come to page 209. 209, paragraph 3. Pursuant to the direction given by the Supreme Court, the committee of 3 judges of this court was constituted. Committee was to separate tented candidates from non-tented candidates. Selected to the executive post by the commission during the chairmanship of Ravinder Pal Singh Sidhu. The final analysis of the report dated 8/2/2007 is as under. Firstly, it is possible to infer that in the process of selection to which the present investigation is limited, there were 40 tented candidates. This inference would, however, be subject to an opportunity to be afforded to them during the course of rehearing of the matter on the judicial side. My lord, this is a type of, I'll say, principles of natural justice, which was adhered to. Hearing of the matter on judicial side in terms of the direction of the apex court in Inderpreet Singh Kahlon. Secondly, the process of selection under reference within the ambit of investigation of the Vigilance Department can be described as fraudulent, tainted, and arbitrary. The said process of selection were clearly ruffled and abundant with manipulations carried out by a well-planned scheme of deception, forgery, and fraud, executed for showing favor or for consideration. And as such, the entire process of selection to the premier executive posts, which were subject matter of investigation at the hands of Vigilance Department, deserves to be set aside in their entirety. So the commission itself, my lord, decided that it should go, the whole thing. Then, my lord, I'll take your lordships to paragraph 12. A short paragraph. FIR number so-and-so dated so-and-so under section 8 and 12 of Prevention of Corruption Act, read with section 120B IPC, registered as Police Station Vigilance Bureau, Patiala, has been registered against Harsanveer Singh, Virinder Veer Singh, Naresh Kumar, Gurbir Singh, and Gurjeet Singh. The accused Naresh Kumar, Gurbir Singh, and Gurjeet Singh have been acquitted on 29/7/2011, whereas Harshveer Singh and Virinder Singh have been convicted to undergo 2 years RI and pay a fine of rupees 10,000 by the special court. Then supplementary challenge are presented against so. This I'm reading it because by that time, so much time had gone, the case is already decided. Then, my lord, your lordship kindly turn to page 230, my lord. My lord, I'll start from 44. In view of the observation made by the Honorable Supreme Court in remand order, an opportunity to file objection was been afforded to the petitioners and the matter has been examined afresh. The learned counsel for the petitioner vehemently raised the following main argument, then the arguments are there. In the light of the argument raised, following substantial question need to be answered, in addition to what may be made, what my learned sister so-and-so has discussed in the judgment. Whether principles of natural justice are absolute, if there is a mass scale of fraud, it's not only mass cheating, my lord, mass scale of fraud, mischief, corruption, and conspiracy to pervert the course of a fair selection by commission, still the petitioner and others competent candidates were required to be given opportunity of hearing, and principles of natural justice and the service jurisprudence was required to be followed before scrapping the entire selection and consequential termination of their services when the entire selection process itself is allegedly violated, and whether the procedure adopted by judges committee is erroneous. Then the last paragraph is 47, madam. The contention of the learned counsel for the petitioners that the principles of natural justice have not been followed before terminating their service by the government. That order stands set aside by the Supreme Court since the services of the petitioner have been terminated. The principles of service jurisprudence will apply. Departmental proceedings have to be conducted in accordance with the service rules and regulation as well as under Article 311(2) of the Constitution of India. An adequate, reasonable opportunity of hearing is required to be afforded. The argument prima facie gives an impression that the present proceedings are akin to the proceedings where principles of natural jurisprudence should apply, as there is a breach of rules and regulations controlling the condition of service of such employee, and such charges are to be proved in accordance with the procedure of imposing minor and major penalty. I am not convinced and also not in agreement with the contention raised by the learned counsel of the petitioners. The principles of service jurisprudence cannot be strictly applied in present case, as the entire selection process has been alleged to be vitiated for the alleged large-scale omission and commission committed by the chairman and others. When the entire selection is challenged and there is no relationship of the employer and employee, it cannot be treated as dispute relating to service under the rules. The service jurisprudence will apply after joining the service. There is an inter-se dispute between the employer and the employee. The basic selection is not issue. Here, in the case, the entire selection by the commission is under challenge. When the entire selection is under challenge is vitiated, then the procedure required to be adopted for removal of the government employees from the service has not relevance, nor it can be applied. But I am only saying that, all right, 311 will not apply. Follow the principles of natural justice. I'm only saying that, my lord, not beyond that. Follow the principles of natural justice. Now, thereafter, my lord, the Joginder Singh case comes. Joginder Singh, my lord, is 2014 6 SEC 644 at page 241 of the compilation. My lord, again, I'll request your lordship to note down the date 23/5/2014. Long time had passed. Those who were charge sheeted, some of them were convicted, some of them were acquitted. At that point of time, this came. The lordship will have 241, my lord. My lord, first I'll take your lordships through paragraph 27, my lord. Is at page 252. The following observation, 252, my lord. The following observations, after noticing and examining each case individually and separately, need a reproduction as it depicts the state of mental and physical exercise carried out by the committee. Having narrated and summarized the factual sequence emerging from the investigation carried out by the officers of the Vigilance Department, the next step is to record conclusion. Before attempting to record our conclusion, we have considered it appropriate to deal with it. The veracity of the statement of Sri Jagman Singh, son of Sri So-and-so, and Randhir Singh Gill, son of Sri So-and-so, as their statement are likely to have strong bearing on the eventual outcome of the task entrusted to us. Accordingly, we have examined the veracity of their statement in subpara A, hereinunder. In this paragraph, it is also necessary to examine the handicap which confronted the investigating agency during the course of its deliberation. The committee on the several occasions felt that on some aspect, further material should have been collected during the course of investigation. These handicaps had been summarized in subpara B, hereinunder. In rendering our conclusion based on the investigation process carried on by the Vigilance Department of the state government, we have in subpara 3C, hereunder, carried out the task of identifying tainted candidates. Your Lordship posed a question, my lord, to some of the lawyers who argued before me, whether they separated the tainted candidates. I did not hear if there was any answer to that, because they were not only non-tainted, they first went to the tainted candidates. We have in subpara C carried out the task of identifying the tainted candidates and candidates who, according to the investigating agencies, are shown to have managed manipulation their recommendations at the hands of Punjab Police Service Commission for the reason other than an addition to their merit. In subpara D, we have recorded our conclusion in terms of parameter expressed in Inderpreet Singh Gehlon case. That is, whether or not it is possible to separate and identify tainted candidates from untainted candidates, and if not, whether there is sufficient materials gathered by the investigating agency to conclude that entire process of selection was bad. As such, deserve to be set aside in terms of the parameter laid down in Inderpreet Singh Gehlon. This is the second case I have. Now, my lord, kindly take your lordships to paragraph 20 and 21.
20, 21.
20 and 21 at page 25.
30 and 30.
20
Yes.
and 21. Man.
We are going back.
My lord, my lord, according to my argument, this I'm showing, my lord, that principles of natural justice is not followed. Tomorrow, even if I'm acquitted, it will have no consequences. No consequences. Lordship will kindly see 20. It was argued by Manoj Swarup, learned counsel appearing for these appellants, that those who are facing trial may be acquitted after investigation. Likewise, some of them who are even convicted, their appeals are pending and their possibility of their appeals are allowed, thereby setting aside the conviction. Therefore, such decision to terminate their services could not have been taken at this stage. This argument is totally unimpressive and doesn't hold any water. Such candidates who were selected with unfair and illegal means cannot have audacity to say that they should be reinstated in service and allowed to continue till their appeals are decided. In any case, having found that they are tainted candidates, their entry into the service was soiled and the decision to terminate their service becomes perfectly justified. Now, what I'm trying to, my lord, impress upon, my lord, is that this is the only chance against an investigation carried out by a police officer is principles of natural justice. Give me a chance before you implicate me. Only chance. Otherwise, tomorrow, even if I'm acquitted, doesn't matter. It will have no. So now, my lord, see my predicament in which I am. And if principles of natural justice is denied by the court also, I'll be nowhere. I'll have absolutely no justice. Now, your lordship will, my lord, as per my argument, I'm placing these decisions. Your lordship will kindly bear with me. Paragraph 14, I'll come to, my lord, at page 248. At page 248, after judgment in Inderpreet Singh Kehlon case, a committee of 3 judges of the High Court, the Lordship will see, if anyone has any faith, it is judiciary. It has proved, my lord, right from emergency, except few exceptions. And my lord, also, in cases, my lord, say case one and the Bharti, if that case was not there and the basic structure had not come, all the lands would have been taken and distributed. Because, my lord, there was no fundamental right after 77. And before there were decisions. So, my lord, it is only because of your lordships that the citizens feel safe.
Because of the constitution, not because of the lordship.
My lord, your lordship has exercised your lordship's power under the constitution. Otherwise, my lord, I don't want to go into, this is a very controversial subject. I don't want to go into at this forum. There may be some other forum. Everybody knows your lordship also. After the judgment in Inderpreet Singh Kehlon case, a committee of 3 judges of the High Court was constituted with a specified task to separate the tented candidates from non-tented candidates selected to executive posts by Public Service Commission. The committee undertook the mammoth task of and painstaking task with a deep scrutiny of cases of each and every candidate. This committee submitted its report on 8/2/2007. It is pertinent to note that the committee could achieve the task of segregating tented candidates from innocent one, meaning thereby the committee could pinpoint those candidates who had got selected and were selected with oblique consideration. In the mean, it meant that others against whom no such tent was found have been selected on their own merit and performance in the written examination as well as viva voce. That is the reason that these candidates were put in non-tented category by the committee, my lord. Police, all were tented. However, even when the committee was able to achieve this result, the mandate of the court in Inderpreet Singh Kehlon, the committee also went into another aspect, namely whether fraudulent tented, namely it could be stated that process of selection could be described as fraudulent, tented, and arbitrary. Looking into the matter from this angle, the committee came to the conclusion that the entire process of selection to the premier executive post were carried out by a well-planned scheme of deception, forgery, fraud, and therefore deserves to set aside in their entirety. So the recommendation of the committee of the judges, my lord, also recommended the entire election should be cancelled. But the Supreme Court, my lord, did not do it. And I'll come to now paragraph 18 first. 18. It is under the heading, my lord, tented candidates at page 249, my lord. The particulars of the candidate who are facing criminal trial are as under. As far as these cases are concerned, they hardly pose any challenge, as it is specifically found that the aforesaid persons have indulged in unfair means and have been selected either by paying bribe or because of extraneous reasons not on merit. Their writ petition have been rightly dismissed by the High Court. My lord, I asked a question after reading 19, who found them tented? Not only police, also the committee of judges, my lord, who separated. So they cannot have any grievances.
So the principles of natural justice were to be applied. They were to be applied even after that. Committee did a in-house inquiry. It was not a bipartite inquiry.
My lord, in-house inquiry, giving us opportunity after the report.
After the report in the writ petitions.
Yes, in the judicial side.
On the judicial side.
On the, well, some sort
Judicial
of,
side, we are hearing, you know.
not only hearing, your lordship will give me relief, you know, on the
We are hearing
principles
from
of
the judges.
natural justice.
So Question is whether the inquiry for these candidates allowed to participate. The
Well,
decision on the judicial side is based on the inquiry report.
Yes,
Because
on the inquiry report also, after hearing, I have just placed it, my lord, Amarveer Singh 2,
yes,
where it says that they were given opportunity and also they were asked, they filed their objections
okay.
to the report.
Mm.
So I'm saying some sort of principles of natural justice was followed. Here we did not even see, my lord, how the decision-making process went on. We did not see the record. And surely, my lord, if a committee of High Court judges go through and separate the tented candidates who can have a grievances, my lord, at least I'll not have. I'll not come before your lordship to argue, no, that is not incorrect. Then, my lord,
But in para 18,
yes,
19,
yes,
the Honorable Supreme Court goes on to say that those who have been charge sheeted, exclude them.
where, my lord?
Para 19.
Para 19 is, as far as their case is concerned, they hardly pose any challenge. As it is specifically found.
So these are candidates facing trial.
That's right. And not only facing trial, they have been already convicted.
No.
And
not convicted, facing trial. Para 18.
it says facing trial, but they have been, there is a double check. When the committee of judges made an inquiry and separated them. Okay. They have been found to be tainted by none other than the committee of judges of the High Court.
Okay.
My lord, I agree with your lordship that yes, in-house, it's an in-house committee, an in-house inquiry, but sort of principle of natural justice has been adhered to. Then, my lord, your lordship will come to 26. 25, it starts the particular of those appellants who fall in these categories of non-tented candidates are agenda. And then before discussing this case, we would like to have a peek into the report of the committee, so-and-so, which is placed on report. The report starts with noticing directive of this court in Inderpreet Singh Kahlon. It is specifically mentioned that to implement the directions contained in the said judgment, the then acting Chief Justice has constituted committee of 3 judges to submit a report on the basis of investigation carried out by the officer of the state government, so as to separate tented candidates from non-tented candidates. Selected to the executive post by Punjab Police Service Commission during the chairmanship of Inderpal Singh Sidhu. Thus, the committee knew the scope of exercise which it was to carry out, namely to separate the tented candidates from non-tented candidates. This aspect is thereafter gone into in detail and with in-depth scrutiny and analysis of record and material placed before it, which not only pertain to the selection process, that is question and answer sheet, but also record which surfaced during investigation into FIRs filed against Sidhu and other persons, including some of those who were selected candidates. No doubt, it was a mammoth task, and it goes to the credit of the committee that it could successfully achieve the same. After detailed and thorough analysis of all the cases individually, the committee was able to separate grain from the chaff, notwithstanding some handicap which came its way and are specifically pointed out in the report. My lord, any such things have been done in this case or required to be done in this case? Or this will become a law that there is an allegation that he has entered into service by bribing, therefore it is proved and you go because you have no right. You have not paid bribe after appointment. Everybody pays bribe before appointment. So before appointment you paid, so you have no right. You had no right even to the principles of natural justice, you will be condemned unheard. Can this be a law, my lord? In a democratic country, and if it is very unfortunate, my lord, with all respect.
Yes.
Now, my lord, I'll show, my lord, paragraph paragraph 49 of the judgment. The internal page is paragraph right? 91. 91. Only the. Learned single judge, my lord, discuss Inderpreet Singh Kahlon and Joginder Pal.
Yes.
Although I had placed these two decisions also, Amar Veer, so these are in the compilation which I filed before him. I'll place it, my lord. Inderpreet Singh Kahlon and Joginder Pal, the Supreme Court had dealt with two categories of candidates who had been selected to the executive post through examination conducted by the Punjab Public Service Commission. They were categorized as tented and non-tented candidates. Taking a cue from Inderpreet Singh Kahlon, this court would hold that if the services are appointee are to be terminated after they have put in few years of service, they would be imperative. What would be imperative are sufficient materials have been collected on the basis of thorough investigation in a fair and transparent manner, and that illegalities committed have gone to the root of the matter. Well, this vitiating the entire appointee is not part of the Kahlon's case. If my lord will kindly, I'm sorry, my lord, I'm troubling your lordship. If your lordship will take 247 of my compilation, I'll just show you. Paragraph 12.1 at page 247. I'll place, my lord, paragraph 12.1. If services of appointee who had put in few years of service are to be terminated, compliance with the following principles by state is imperative. Sufficient materials are to be collected and to be gathered through investigation in a fair and transparent manner. This Learned Singh has said. Thereafter, illegalities committed must go to the root of the matter, vitiating entire selection process. The entire word is missing, my lord. It's conspicuous by its absence. And that appointee must be found to be part of fraudulent purpose, and the system itself must be found corrupt. Applying those principles, there are no denying fact that against each of the writ petitioners, sufficient materials have been collected through process of investigation. And materials so collected disclose grave irregularity in employment. The gravity of illegalities found to have been committed was such, it has gone to the root of the matter, therefore vitiating the selection. Vitiating the entire selection was actually interfered in Inderpreet Singh Kahlon's case. In Joginder Pal, in respect of the petitioners therein who were found to be tainted and facing criminal trial, Supreme Court held the fate of such candidates do not pose much challenge, as it was found that they indulged in unfair means and were selected either by paying bribe or because of the extraneous consideration, certainly not on their own merit. These are not there, subject to correction. And plus, they were found, my lord, by the committee of judges that these fellows were not tainted. This is not on the basis of police investigation alone that the Honorable Supreme Court had held this. Then your lordship will see. This precisely is the case of the writ petitioner herein as revealed from the police report. Although the petitioners were discharged from service by taking recourse to provisions governing service rules relating to discharge of the petitioner, which stands out predominantly, is that such discharge from service was in view of commission of illegality and selection involving, your lordship kindly see, identifiable group. So it's not a case where, I'll not use the word mass cheating, mass corruption, mass bribe. It's not a case, it's a group of identifiable group. The group which can be identified. So what was the difficulty in giving them notice? The even if, my lord, suppose the principles of natural justice is applied and we are given a chance to rebut the allegation, we are not going to write the order. Order will ultimately have to be written by some authority, and they will write on the basis of the investigation. What harm would fall on them if principles of natural justice is applied? But it is otherwise, because your lordship knows the how investigations are done.
No, don't ask us to comment on that.
No,
Investigations,
I'm not commenting
investigations
because-
are fair also, Mr. Mishra.
My lord,
That is why the society is surviving.
my lord,
Where the police forces are weak. Look at the plight of the people. Need not identify the places.
my lord, I'm not making a general comment, but most of the cases that I have seen, I have done, it leaves much more to be
That is
desired.
right. That is,
And I'm
you are
saying that,
correct on that.
lordship,
Yes.
Find that. Now, my lord, what is the case of the government? The lordship has, in our case, is in paragraph 15, short case. You did not give me opportunity. Your order of discharge is liable to be set aside. This is our case. Now, I will just sum up, because I think there are 70 paragraphs, 83 paragraphs. I will just sum up. The first case is that we have secured the appointment by fraud, and we are not entitled to remain in office. This is the first ground that they have taken. This is in paragraph 48 and 51. Of course, there has been repetition. I'll not take your lordship through, but this is their case. I'm just giving paragraphs in case your lordship like to go through. Paragraph 48 and 51 at page 162 of my paper book. Internal, I will just tell my lord. 162. My lord, internal 20 of their page. But I think I should tell you. This, huh? All right. My lord, internal page 20.
Now we are having the judgment.
So the first is that we secured appointment by fraud and not entitled to remain in office because the entry itself is tainted. Then they say, settled position of law that any probationer is liable to be discharged at any time without notice. I'll just add here, if he is found unsuitable for the post, not at your whims and fancy, that the superior officer would not like, therefore probationer has no right to the post, will throw him out. That you cannot do. If he is unsuitable, yes, by all means, you have the power. Then, my lord, the next, this is, my lord, stated in paragraph 58. 58, they have stated. Page number to bataya, it's the page number to
58, no, there is no para 58. Judgment ends at para 56.
My lord, I'm sorry, I'll just. No, not judgment, my lord. This is their AO I'm talking, AO. Their affidavit in opposition at 166.
Okay. You're referring to paras of the affidavit.
Yes, my lord. Earlier also, my lord, I referred their paragraphs 48 and 51 is their AO. If your lordship has pagination is done running pages.
Yes.
If it is running pages, my lord, then it will be easier for me to tell your lordships the paragraph and then.
Yes, we have the running pages.
My lord.
Page
58, paragraph 58, page 166.
Well, the problem is that affidavit is Mr. Kohli file is in one file probably. Which file?
My lord,
you are reading from your compilation.
In this case, that's the only affidavit. In
Sabira Imran.
There's only one affidavit, and that is Mr. Kohli's affidavit.
That is page
running page is 166.
166. Yes. Moniratna Mahanta. Moniratna Mahanta.
Yes, he has filed. And this starts at
166. Yes. 162 is the para 48.
162 is, that's what I said. 162 is paragraph 48 and 51. And one of the other point they have taken is settled position that a probationer is liable to be discharged anytime without any notice. That your lordship will find at paragraph 58 at page 166. He can be, but my lord, I just add a thing that provided he is found unsuitable, not at the whims and fancy of the officers. Then the next, my lord, will definitely have surprised me. They say that it is not reasonably practicable to hold an inquiry. And the case is squarely covered by exception to Article 311(2). That, my lord, will find at page 168. 168.
Yes.
I'll just read out this. Because, my lord, if their case is that we have committed fraud and we have no right to remain in service, or that we are probationer, we can be, our services can be dispensed with any time at their whims and fancy, then how do I have not been able to reconcile this, that this is a case where it is not practicable to hold inquiry. Then you are contradicting yourself, the government. I'll just place it. Without prejudice, I'm placing paragraph 65. Without prejudice to above, it is most respectfully submitted that in terms of proviso to Article 311, whenever it is observed that it is not reasonable, practicable to hold inquiry, any such inquiry, and we say under Article 311(2), it will not be necessary to give such person any opportunity of making a representation, and the said provision shall not apply. In the present case, having regard to the material which became available during the detailed and thorough investigation being carried out by Assam Police, where the beneficiary of the colossal fraud in recruitment process have been found to be unfit in service in public office, it has been found not to be reasonably practicable to hold inquiry, and as such, proviso B to Article 311(2) squarely applies in the case. My lord, kindly have that article. Your lordship may have gone on 10 times. Your lordship will take Article 311. Again. Your lordship got me.
Yes.
I'm placing 311(2). No such person as aforesaid shall be dismissed or removed or reduced in rank except after inquiry in which he has been informed of the charges against him and given a reasonable opportunity of being heard in respect of those charges. Then I come to second proviso. Provided further that this clause shall not apply, I'm reading B, where authority empowered to dismiss or remove a person or to reduce him in rank is
So reasons
satisfied.
for dispensing with the inquiry have to be recorded.
Reason has to be given. If their case is that it was not reasonably practicable to hold an inquiry, then kindly give reasons
For dispensing with the inquiry.
for dispensing with. But there is nothing. Now, my lord, that day I handed over, my lord, Assam Service Discipline and Appeal Rules 1964. If you like it. 1950.
Yes. Yes, we are having those.
My lord, it is, apart from the constitutional requirement, this is requirement of the rules also.
Okay.
If my lords can have a rule 9 at page 8, Assam Discipline and Appeal Rules. Who is it? Nine is procedure for imposing penalty, my lord. Without prejudice to the provision of Public Servant Inquiry Act 1850. If your lordship require, I have a copy of this. I have got. No order imposing on a government servant any of the penalties specified in Rule 7 shall be passed except after an inquiry held as far as may be in the manner hereinafter provided. Now your lordship comes straight to 10. 10 is an exception to rule at page 13. Special procedure in certain cases. Notwithstanding anything contained in Rule 9, man, this is the non-extante clause.
But this is the reproduction of basically
Same, my lord.
311
So therefore I said it is not only requirement of constitution, of course, that itself is enough, but even in the rules.
Mishra, the argument which you will have to meet is whether it is a penalty, whether it is at all an order imposing penalty.
My lord, this I have, my lord, all respect, my lord. I'm thrown out of the job. I'm out of job. It may not be discharge itself, may not be a penalty. But there are circumstances in which it will be penalty and the circumstances in which it will not be penalty. Here, I have been removed on a certain allegations that your lordship has seen. So therefore, it is, my lord, it's a kind of punishment. It's not a discharge simpliciter.
Okay.
It's by way of punishment. This is my case, whole case. Right. My lord, pre-lunch, which I argued. I showed, in fact, I took your lordship through paragraph 65 of their affidavit in opposition at page 168, wherein they say it was not reasonably practicable to hold an inquiry. So the order doesn't speak true. That reason is only known to them and they have said. And I have also placed Article 311(2), second proviso B, which says the reason is required to be given, as well as Rule 10 of the Assam Services Discipline Appeal Rule 1964. Now, my lord asked me that the order is not a punishment. In fact, my lord, this is a settled law. And who will know better than my Lord Chief Justice? I'm saying it because your lordship has held so.
Professor claim to be knowing all these things.
No, your lordship may not claim. But my lord, we on this side of the bar, we try to inquire before a person is coming here as a Chief Justice, and then we come to know. And accordingly, we prepare ourselves. Now, my lord, form of the order is immaterial. Though if your lordship can kindly see the discharge order at page 135 of the paper book, the 135. 135.
Yes.
The government of Assam, in exercise of power conferred under 16B of the Assam Police Service, is pleased to discharge Srimati Savira Imran, APS Probational Assistant Commandant so-and-so, under suspension from service with immediate effect. This type of order is there in all the cases, at least in 2 cases where I'm appearing. So this is an innocuous order. And in such cases, my lord, Supreme Court way back, my lord, in 1984, no? In Anup Jaiswal case, my lord will be knowing Anup Jaiswal case, said that the veil can be lifted. I'll just read, because in this case, your lordship don't have been spared rather to lift the veil. They themselves have lifted their veil to show that it is by way of punishment. And had they not lifted, your lordship could have. Now, your lordship will see paragraph 12 at page 379. 379.
Yes.
It is therefore now well settled that where the form of the order is merely a camouflage for an order of dismissal or misconduct, it is always open to the court before the order is challenged to go behind the form and ascertain the true character of the order. If the court holds that the order, though in form is merely a determination of employment, is in reality a cloak for an order of punishment, the court would not be debarred merely because of the form of the order in giving effect to the right conferred by law upon the employee. This is enough. So now here, if your lordship will see paragraph 48, then 48 or 58. Give me.
48 of?
My lord, their affidavit in opposition.
Yes,
please. At page 162, my lord. The petitioner was serving on probation. The respondents filed notification dated 27/7/2018. I've just placed this. In exercise of the power conferred under Rule 16B of the Assam Police Service Rules 1966, discharge the petitioner from service with immediate effect. This is without prejudice to the submission that all these cases in the present batch of writ petition are cases of securing appointment to public office by fraud. The petitioner are not. So they themselves have lifted the veil that it is by way of punishment. It is by way of imputation of fraud without even complying with the principles of natural justice. Give me that compilation. My lord, kindly come to 16B, page 7 of this compilation, my lord, that in file in this case, the compilation of decisions.
Yes.
A probation, page 7, my lord. A probationer shall be liable to be discharged from service or in case of person appointed to the service under clause B of Rule 15(1), be reverted to the post of Inspector of Police if this is in case of promotion. Fails to pass departmental examination within the period of probation or is considered otherwise unsuitable for reasons to be recorded by for continuing in the service by the governor. Here also reason has to be given. And the reason, of course, there is no reason in the impugn order passed under 16B. They have not given any reason. And they're saying it is innocuous. And at the same breath, they are saying that this is because of the fraud that they have done it. Then they say we are not entitled for notice. Then they say, okay, it's not reasonably practicable to hold inquiry. All kind of my lord, pleading has been pressed into service before lordship. Now, my lord, now I come to the sheet anchor. I'll try to build up a case. Misconduct before appointment. Now, Rajasthan case is, my lord, Virender Kumar Taylor versus State of Rajasthan. I have the copy. I'm giving it to your lordship. This is a direct benefit, my lord, of the conversation that we had on that day. Otherwise, I would not have known. Now, my lord, if your lordship permit me, I just place the case.
The single bench judgment, what happened in the division bench, Mr. Mishra?
My lord,
we don't know.
My
Maybe
lord,
this
what I'm
judgment
saying-
may have been challenged in the division bench.
So it
I'm
has
not sure.
We didn't see that it was marked red. Normally, my lord, red, that also now I will confirm. But the first thing that I tell my juniors, when you see whether it is marked red. Because if it is overruled or it comes, my lord, red. But so far, I have not, but we will again check and I'll let my lord know. My lord, the facts of this case
Yes.
is relatable to something which has happened before the inquiry.
Hmm.
The person has obtained a B.Ed certificate from Purvanchal University, Jaunpur. That was, my lord, prior to his appointment. And then he placed his, my lord, certificate, graduation degree, before the B.Ed degree, before the authorities. And on that basis, he was confirmed. Now, this was a misconduct prior to his appointment, namely obtaining of the fourth certificate. He did not do it after he came into service. He did it before. Then, my lord, the government of Rajasthan has a rule in force that my lord will find.
Rule 35.
3. Rule 35. Rule 35, the decision of the government of Rajasthan is based on Rule 35B. My lord will see internal page 3. Government of Rajasthan decision I'm placing. Instances has come to the notice of the government or competent authority having issued order confirming temporary or officiating government servant in permanent post, even though the government servant is not qualified in all respect for confirmation under the relevant statutory or service rule, executive orders or administrative instruction. In almost all cases, the confirmation so made had the effect of depriving or postponing the confirmation of the other government servants who were qualified in all respect for confirmation. The possibility and propriety of cancellation cancelling the erroneous order of confirmation already made and has been examined, and it has been decided as follows. An order of confirmation which is clearly contrary to the relevant statutory rules or service rules may be cancelled by the competent authority straightway. Here, the order of confirmation was ab initio void, as it ultraviolates the relevant rules, and cancellation of the order would be justified on the ground that was not a valid or subsisting order at all, and the act of cancellation is a mere formality. The effect of cancellation would be to put employees concerned in position of never having been confirmed. I leave the others, come to the last part. It would, however, be in consonance of the principles of natural justice that the notice of show cause, why the order of confirmation should not be cancelled, be given to the affected party in both types of cases specified above. So, principles of natural justice is sine qua non for passing any order, my lord, which adversely affects a person. Now, this, my lord, this person, when the show cause notice was issued, your lordship has noted it, I'll take your lordship's view, he did not reply. But he makes a false claim that he has replied, and they did not dispose of his representation. But the fact of the matter is, if FIR was lost, and that, my lord, FIR was lost by the district education officer, and he was acquitted in 2007. Thereafter, he filed this. And my lord, the relevant portion, your lordship, is at page 9, my lord. Paragraph 9, I'm sorry. Paragraph 9. Your lordship dealing with the rule. From the language of the your lordship government, paragraph 9 at page 4. From the language of the above quoted rules and the decisions taken by the government, it is evident that the competent authority is empowered to cancel the confirmation or appointment of a government servant in the contemplated circumstances. Obviously, as the petitioner degree was found to be forged and fabricated upon verification, his appointment and confirmation to the post could be very well be termed as to be erroneous, and consequent cancellation of action of cancellation was thus permissible under Rule 35B and the government decision taken thereunder. Though the petitioner claimed in the writ petition that he replied to the show cause notice, show cause notice annexure 7 dated 25/6/1992, but considering neither the date of reply is mentioned in the writ petition nor copy thereof has been annexed so as to accept the said amendment.
It was a case of acquiescence. It was held that there is an acquiescence on part of the
yes, my lord.
employee. Yes.
patently denied that the petitioner ever replied to the show cause notice. It has thus been held that the petitioner did not reply to the show cause notice and appears to have acquiesced to the term, and as consequence, the district education officer was totally justified in passing the order. Now, your lordship, here, my lord considered the effect of acquittal in this case. In 1915, my lord. Then,
In spite of acquittal, the
yes,
removal order was
yes,
affirmed.
yes, my lord. This, my lord, at paragraph 11,
Is not much relevant to the present case, Mr.
my lord.
Other than your argument regarding principles of natural justice.
Principles of natural. Now, my lord, for example, there are cases, your lordship was saying there are a number of cases, I've gone through all. My lord, there are cases where, one is of course Rajasthan case. There are cases where there is form, which requires certain information to be given. Say whether you have been prosecuted,
Criminal case.
whether you have been my lord, convicted, and in the form, if the person says, no, I have not, verification will obviously be done by the government, and the government does the verification and finds that no, what he has said is incorrect. In that case, my lord, that there also the notices are given. Principles of natural justice will have to be followed. My lord, here in this case, in Rajasthan case, especially, my lord, I'm sorry, I'm repeating it, but my lord, assuming for a second that the allegation was not correct, as some certificate he produced during the trial, he could have taken some time, gone to the university,
Got a verification.
got a verification done, and also get a letter that letter was written by some person who was unauthorized, and this is the thing. I think once that authenticity was proved, he would not have been, my lord, dismissed from service. He would not have been. So that is the reason the principles of natural justice is required to be followed. Otherwise, my lord, if principles of natural justice is not followed, then nobody is safe. Now, now, my lord, I need not trouble you because some thing I have placed that there is no difference between a confirmed employee and a probationer insofar as 311 is concerned. The Purushottam Lal Dhingra is the first case, 1958. It says so. I need not trouble, my lord. Para 21, your lordship does have a glance. This has been followed in Purushottam Lal Dhingra, in Shamsher Singh.
He referred to it extensively.
My lord. Shamsher Singh I have referred already, so this has been referred. Few lines, if your lordship, so please. Article 311 does not in terms say that protection of that article extends only to persons who are permanent member of the service, who hold permanent civil posts. To limit the operation of protective provision of this article to these classes of persons will be to add qualifying words to the articles which will be contrary to the sound principles of interpretation of the Constitution or a statute. In the next place, clause 2 of Article 311 refers to such person as aforesaid. And this reference takes us back to clause 1 of that article, which speaks of a person who is member of a civil service of the union or the state. These persons also come within Article 310, which besides them also includes persons who are member of defense service and who hold any post connected with the defense. Article 310 also not in terms of the terms confined to the persons who are in the service, therein mentioned. To hold that article covers only persons who are permanent members of the specified service and who hold posts connected with the service therein mentioned, will be to say that the person who are not permanent members of those service and who do not hold permanent posts therein do not hold their respective office during the pleasure of the president or the governor, as the case may be, a proposition which obviously cannot stand scrutiny. These are the law. The basic thing is there cannot be any difference if you are removing a person from service on the basis of certain allegations, imputation, you have to follow. Here is the principle of natural justice has not been followed. And my lord, I'm sorry, I forgot, my lord, to place paragraph 11 in the briefing or Keharsing, which one they give me. I'll just bring up, my lord. I think Joginder Singh, my lord. Joginder Singh is there. Joginder Singh. 241. Yes, my lord, at page, sorry,
Yes.
at page 246, my lord. Of the compilation of judgments, paragraph 11. I will just show the last two lines. I don't think Mr. Digonto Das is waiting. He has to go, my lord. So I will not take much of the lordship's time. My lord, relevant two lines that I want to place, my lord, your lordship will get at page 247. The last two lines of paragraph 11. It was thus held that the High Court was not right in applying the principles of mass cheating in the instant case. Because, my lord, the High Court said that principles of natural justice is not required because it's a case of mass cheating, depending on, my lord, relying on Bihar case, 1970, which your lordship said that this is only admission. But that was the case which has been followed because the principles are the same. So, my lord, in view of all this, my submissions would be, my lord, that these young boys and the ladies, my lord, have been punished without giving them any semblance of opportunity. And those, my lord, who can afford, they are still in service.
Is there a pertinent ground in your writ petition regarding those three who turned approver being still in service?
My lord, I have written in my, because I came to know later.
But that's not a part of the pleadings.
That's correct. Because
then the respondents have no.
My learned junior said that there is an additional affidavit. My lord, in reply, I will place.
You pointed out because otherwise the other side would have no opportunity
to
controvert that submission.
My lord, but that, correct.
If it is there in affidavit, you let us know.
Yes, yes. I'll
Mr. Kohli, you have to take note of this argument. This is a significant. Mr. Kohli.
Yes, Lordship, I can hear Lordship. My mic was off, Lordship.
There is a pertinent argument coming from Mr. Mishra that three of the similarly placed officers who were also found involved in the same scam, they turned approvers and their services were not terminated akin to the appellant's hearing.
Yes, Lordship.
Yes. You will have to address the court on that.
I will, Lordship.
Yes.
Meanwhile, I'll find out. My lord, I'm always grateful, my lord, ever grateful to your lordship.
उसका ना वो opinion निकाल देना.
I become a fourth down player.
No,
So
you
always
are.
I go back.
You are in the capacity of virtually the one down batsman in the yesterday's match.
My lord, I go every day because I was not before learned single judge. I was division bench. So I didn't know what type of argument the learned, my all colleagues has argued the matter. That's why I try to remain present in the court and look the argument.
So you will bring in a fresh perspective.
So my lord, I always go and prepare. Always I go and prepare whatever the query that's been asked. But always covered up by my learned senior friend. That's the whole problem. Again, I have to go back. But what your lordship has pointed out, and what my learned senior friend, the three particular, my case will be a bit of different, not three. On the face of it, also there are huge. On the face of it, also it.
Okay.
Face of it, that's a one aspect. But only to keep pace with my learned senior friend, I'll just, my lord, three candidates I am appearing.
Okay.
One is your lordship can note down, which has not been argued, writ appeal 50 of 2021, item number 32. That's a police service, my lord.
Okay.
And my lord, in connection with that, there's a writ appeal 333 of 2021.
Item number 40.
Item number 40, my lord.
Again, police service.
Again, police. Why? Now, my lord, what has happened? I was hearing lordship argument and my learned senior friend. There is one document in the APS, police service, which was shown before your lordship regarding their transfer in 2017. And your lordship has asked, which my learned senior friend argued, order has been by principal, his principal secretary, It is a governor in the name of the governor.
His name.
That's, my lord, is admitted.
Yes.
So last part of the order itself, they have completed. Your lordship will kindly see that they have completed.
That
And,
was argued.
and that's not argued. That's what your lordship has said. One thing I remember. OM has to be read into. Why that OM? OM was on the ground I've inquired. It is once you complete, that OM will prevail to those candidates of confirmed service. Now, that question was asked, we file a separate writ petition. Why? Because only to cover up that particular, my lord, the document which we were transferred, a notification was issued in 2018. That was query whether you could have filed. We file a separate writ petition, that is 998 of 2019, which is now, my lord, culminated writ appeal 50 of 2021.
Fine.
That I will try to bring. This is the writ petition. No, I know. Writ petition. First, my lord,
It's not which file.
now
want
your
us to take up
lordship will
first?
kindly take the file of
Item number 32.
item number 32 and 40 together. 32 and 40. 32 and item number 40. I want to keep pace with so that your lordship was asked, that's why I noted down. No, I think new note, no?
50/21.
Yes. My lord will kindly see item number 40, my lord, will kindly turn to item number 40, which I think Mr. Chaudhary has appeared. For item number 40, is appeared. But one of the candidate which have appeared in other case, that appellant number 5 in this case, your lordship will kindly see the cost title at page 2, my lord. Dilip Kumar Kalita, my lord. This I appear in other case, writ appeal 50 of 2021. Right.
So he
Now-
is a petition appellant in that writ also.
Yes.
Why is that so?
No, that's why I am showing it. Why? That's so. My lord will kindly turn to page 69. 69. I'll not trouble because your lordship has heard the facts and all those things. Kindly see page 69. That's 15th of September 2017.
No,
Your lordship has gone through it.
69.
Page 69.
That is a certificate of NEPA.
333. No. That's a
Item number 40.
item number 40, my lord. 40, my lord.
Yes. Yes.
Why to read petition? I'll just explain to your lordship why to read petition. My lord, this is 15th of September 2017. Lordship got it. Now, please kindly turn to page 71.
Yes.
This is bottom below for the third last.
Dilip Kumar Kalita.
Yes,
IPS.
this lordship, right, my lord. Now, kindly turn to page 73 now. 73, which my learned senior friend read this and your lordship has also read. The above posting of APS junior grade have completed probationary period of 2 years and are exempted from mandatory posting in battalion for a period of 4 months as per OM dated so and so, as the service are urgently required in the field and in the specialized agencies, CID border, due to shortage of officer. So once you complete it, my lord, there is an OM which you have to go through it. Now here is the case they exempted because the reason is required, my lord, urgent
requirement
of so and so, right, my lord? Now kindly turn to page 74. I am taking an example of a particular one of the officer. Now 17/10/2007, lordship got it. With reference to rule 145, I understand, I have the honor to report that I have this 17 October handed over in charge so and so deputy superintendent police provision. Now kindly turn to next page on the same date at page 75.
Number is 40.
Now number is 40, my lord. 74 if you see. Now memo number above in 74. Memo number and kindly the 75 is 40A, bracket 40A. And kindly see with reference to rule 145 of so and so, I understand the so and so received charge of Deputy Superintendent of Police so and so. Once I complete, then it is my lord. This is what I
That
am.
argument was made by Ms. Chaudhary, deemed confirmation.
No, this is my lord. I am not on deemed.
Then
I am that it is my lord or confirm. It is
the
a
law
type
is,
of-
Mr. Das, the law is to the otherwise. There has to be a specific order of confirmation in service. That is the law. But what does the OM read? Let us see the OM.
Yes, this
Where's
is the
the
OM. I have given a copy to your lordship.
Yes, read.
Yes. 30th of August 2004. Lordship got it?
Yes.
I typed out because this is not very legible, my lord. That's why.
So the
my-
this only reads that compulsory posting of new recruits
Yes,
in the battalions will not be necessary if they complete the 2 years probation period.
right. My lord, now kindly see, now is reduced from 1 year to 4 months. Earlier OM it was 1 year, now it reduced to 4 months. Now what I am saying, it is not what I am saying, dim. It is completed. Once you complete, then
What is the effect thereof? Can't it be extended?
now what they have done it, what I am saying. After completion of, kindly see, my lord, after completion of the prescribed provision period, kindly see the OM, my lord. I am sorry to trouble you again, your
No, no,
lord.
not an issue.
No, after completion of prescribed provision period.
Of 2 years.
Yes, only it is only in respect to confirmed employees. This OM cannot apply to provision. So how can this OM will apply to a provisioner, my lord? No. Kindly see, will not apply. After completion of prescribed provision period.
This is only for the purpose of reducing the compulsory posting in the.
No, but this doesn't apply to provision, my lord, with great respect what I want to say, my lord. Now, my lord, for a moment, what they have done it, my lord, when the writ petition was filed, now what they want to cover up the pendency of writ, what they have done, kindly see at page 91, my lord, kindly see 91. They brought it by an additional affidavit. What made to bring, your lordship has said, whether this was put to challenge, what I was during the proceeding, I was hearing it. Kindly see, my lord, why the second writ petition at page 91. This is 20th of January 2018. Lordship got it, my lord?
Yes.
And my order, which was passed, was on 17/10/2017. Kindly see the order, my lord.
Yes.
Whereas, see, Dilip Kalita, so and so appointed a provision, so and so. Whereas the investigation by Dibrugarh police is going on in the recruitment of APSC other allied service officer of 2015 batch. The government is not in a position to form the requisite satisfaction in respect of Dilip Kumar Kalita. Therefore, the service of above mentioned officer is not proposed to be confirmed at this stage. Now, therefore, the government exercise of power so and so is pleased to extend the period of provision so and so. So now, this is brought by an additional affidavit. When we raised this, then when they brought this, my lord, it was taken a surprise. How you additional affidavit? So our option was twofold. Either you challenge it. Now this has been put to challenge before the learned single judge, which is, my lord, your lordship will ask, why the second?
Okay.
This is, my lord, will kindly now 50 of 2019 has been put to challenge. Challenging this, my lord,
Extension of probation.
correct, my lord. This is
And
what
what is the judgment on this?
nothing, my lord.
That
By common
didn't require-
judgment.
Because that didn't require adjudication
That's
presumably.
my lord, but our whole case was also projected by a second writ petition. Now, my lord, if the position is that if the learned single judge would have decided this and say that no, these are the class of the APS officer. Now you are a confirm, so a notice is required. Situation would have been different. It had a material bearing on the outcome of the. So it would have been a material bearing on the outcome of the writ petition, my lord. That's my submission before this, because I don't want, because all has been argued. What I want to show addition, my lord. What additionally we have taken this point and we have challenged it, my lord, by a writ petition, which has not been decided because learned single judge, these are all on the same pedestal. Now this writ appeal, 50 of 2020 has been, my lord, against the order of the learned single judge, because separately it was filed. A specific prayer was made also to set aside this notification, my lord. Now this kindly see. Notification Prayer is at page 59
In which appeal?
of writ appeal. We have prayer of this, my lord, 333. Kindly see 333, my lord. 333. Kindly see the prayer is at page 59. See, kindly see, my lord. See,
Just,
at page 59.
yes.
Mandamus shall not be issued directions to recall, resign or cancel the improved notification dated 21/2000 as well as notification dated so and so. So specifically, we made a prayer, my lord, on this and we file a separate writ petition.
Okay.
This extension was put to challenge. How you can say now, only to cover up all those APS officer, you have issued this notice. And very interesting, I asked the client, what about informing to the other departments? It has been informed, they made an RTI. And they found that this notification will not inform to any other departments. And kindly see that notification, my lord.
What about the gazetting? Whether this has been published in the
No,
gazette?
we don't have any. That's what reply has to be filed. They have to give, Mr. Kohli has to say before. Kindly see at
Where
page
is Mr.
91 once
Kohli?
again.
Mr. Kohli, why he has left the hearing? Is there? Mr. Kohli?
My lords, Mr. Kohli is in his legs, my lords. He will take 5 minutes. my lords.
It's a little, is it not unfair on his part? We are in the midst of hearing of a very important matter. All right, you answer. Where is the gazette notification of this order?
My lords may give me 5 minutes, my lords. He'll be here. I'm informing him, my lords.
All right.
Now, my lord, kindly see the notification of page 91, 333 of 2021. RTI we made an RTI. We made an RTI which you are several RTIs we made.
91 in which appeal?
In 333. 333.
Yes, 91 is the notification dated 20th January.
Which we have put to challenge, my lord, which
Yes.
I have shown. Now, down below, kindly see, my lord. Copy to kindly see. These are the authority, they ought to have sent it. They ought to have sent it.
We'll ask them whether, what is the situation of gazette?
And kindly see, it should be addressed to all the candidates also. Kindly see, where is the address which has been made? How you have done it, only for the purpose that now you know that you want to cover up, that they are confirmed, the notice is required. So that is why you have done it. We know it, my lord. That's why I know that it goes before the appellate court, definitely which your lordship has asked, whether you have challenged or not. And kindly see the RTI at page 230. Now kindly see 231. Additional Director of Police, with reference to subject cited, I am directed to inform you that after checking our records, lordship got it at page
more important would be whether there is a gazette notification. That will be a more important issue.
That's your lordship, they have to give a reply. Only this is what I am saying, only to cover up.
After 11 months,
After 11 months, they have brought this. After 11 months.
There will be one more question, of course.
Yes.
Which has not been argued. What is the status of the period in between the completion of 2 years and this order being passed?
Yes. Yes, my lord, I think, well, a senior friend has raised all these points. So I thought, my lord, I will not trouble with all those arguments, only repeating purpose. I thought I will show this before your lordship that this particular, all these officers of APS.
This kind of order has been passed for all officers?
All the officer APS, all the officers. That's what I have, my instruction, my lord. Your lordship will kindly, my lord, Mr. Chaudhary also. I thought that I should bring notice to decode.
Mr. Chaudhary read this order.
But I thought that I should bring notice to decode. These are all.
He argued this argument was raised about the gazette notification not being there. Then we pointed out that it has been sent to the government press. But whether it is just a narration in the order or actually.
All your lordship wants to see whether it's a gazette notification.
none of the departments are.
But what is surprising, my lord? Well, none of the department has received. This is what I wanted, my lord. I asked they said, no, we made an RTI. And we found that none of the departments, neither it was addressed to us.
This is a part of pleadings of the writ petition or the writ appeal?
No, yes, separate writ petition has been filed. That's why your lordship will ask me why this separate writ petition. That writ petition, my lord, is 7-1. No, writ petition is 9.
All they have, this is challenged. I'm also told, because there was no pleading in my case, I didn't in this thing. But I'm told there are writ petitions everyone has filed challenging that order. And your lordship has, my lord, asked one question. It is in the pleading which I have said that these persons, and apart from that, my lord, a departmental inquiry was held for a particular person, and that has been brought in paragraph 2 of item 9 of the writ petition. I was representing that person, my lord, in the writ court, not here. So we brought it. I will show it, my lord.
Departmental inquiry?
Yes.
Against a particular person?
Yes, against a particular person, he was reinstated. In paragraph 2 of that.
Reinstated after?
After inquiry.
Okay.
He is, if your lordship permit me, I can.
Who's representing? Anyone was representing that?
I was there, my lord. I represented this person in before the writ court, and during the pendency of the incident writ petition, deponent has come to know that government has proceeded with the departmental proceeding against one of the co-accused in Dibrugarh PS number 936, Syed so and so, accused number 8. Mr. So and so has been exonerated from charge in the said departmental proceeding by order number so and so. The accused has also been reinstated by order dated number so and so dated 21/11/2019. Specific amendments. I will paste it, my lord, and I will also show what are the reply if there is any. I'll show.
Yes, Mr.
My lord, while I'll just clarify it, 998, the writ petition, which is now appeal, writ appeal of 50 of 2021, that's a point out of discharge, my lord. But while this matter was under adjudication before the learned single judge, they filed an additional affidavit bringing this notification. After 11 months. That's why we challenge this, my writ petition 7122, which is writ appeal 333 of 2021. So, my lord, if your lordship, now they have to answer to it, my lord. If that be the case, my lord, then these officers, my lord, of course, my lord, they are entitled to get a notice.
Yes,
So I will not say much about this, my lord, because I don't want to repeat, and already repetition has been it's an argued. That's why I'm saying, my lord, my turn is a 4th-down player. 4th-down player is very, all the time I note down, and I think mornings are my learned senior friend. Cover up, my lord.
That credit you have to give him.
But what but there are 2 other candidates. Your lordship very pertinent. I was just listening that whether the approver, this accused has been turned as an approver.
Mr. Das, wait for the response of Mr. Kohli.
Yes,
then we'll
no, where not only that's not in the case, what your lordship will be shocked. Because what we are, but the propositional law is very clear, which I agree to the senior friend, Mr. D.K. Mishra, and what your law. Police report, it can be discharged. I have gone for it. There is no hesitation, doubt of it. But these are laid down law, my lord. How can I interpret in a different way that I disagree with my learned friend, my lord, but I am saying what is a law laid down. But to what extent the police report, my lord, your lordship is not making a roving inquiry, which was before the government. What they have done it? Well, I found after reading it, whether the segregation was made, let us forget and close this. Let us say what they have done it. Now, Kohli has to respond to this. Whether, my lord, segregation was done it. My lord, your lordship, very interesting. The information, let us say police report is the information which is given to the government. What is the information they have gathered? Which my learned senior friend has said, a colossal fraud by them. Colossal fraud is a mass fraud. If it is a mass fraud, my lord, it is a mass fraud, then my lord, what it requires, there is no question, and mass will go.
Scrap the
entire proceeding. You chose that 60 candidates, which we are before this court. Whether any notice is required, that my learned senior already has addressed, I don't know, repeat it, my lord. What I am saying, my lord, the report information which is given to the government, they have received the information, my lord, 161, charge sheet, the FSL report, my lord, very shocked. If your lordship go to FSL, your lordship was asking one question which I remember. But these are all answer script with a duplicate answer script. I checked the FSL report, but 207, we are entitled to get the copy. 207. I have annexed it. The FSL report, I have brought into notice of the court. FSL report.
That point of time,
It was not that at that point of time, what my learned friend is saying at that point of time. Because all the material were before the learned single judge. But when we were served with the 207, the FSL report, we got it. And that duplicate in respect of one of the candidate which will come up tomorrow, I will, because I'll give a note to your lordship. I am just giving an aerial view of the entire case, my lord.
Okay.
My lord, this candidate which I am representing, who belong to taxation, one Manas Patim Haloi, my lord. If your lordship, I'll show your lordship, FSL report doesn't say it's duplicate. So how you have segregated? This is what with great respect to the IO, we don't have a faith on this IO, my lord, who submitted a report to the government. He left out 9 tabulation seat, your lordship is known very well of a criminal lawman. 9 tabulation seat, I'll show my lord, he has kept with him. 1,000 days he kept with him. Only for the purpose of shielding some of the candidates who are still on job. Your lordship has asked whether they are still on job on the same pedestal. How can you leave those? We brought it by notice before this court by an additional affidavit. And what interesting, my lord, will kindly see, we made a chart for convening the court, not prosecuted. There, your lordship will sign FSL report, officer kept it. After 1,000 days, he sends it. And when the FSL report was completed, he kept quiet.
He does not go to.
He doesn't go to the office. After the 3 months, now there was an inquiry. There's a committee which was formed by DGP. Said that no, what has happened? He got my law immediately. He said, no, I have to send it. There'll be an inquiry against me. He sends it. I have been told my learned friend is from the trial court. It has not been marked also. He just, your lordship will call it.
The marking would be during the course of the trial.
What type of, this is what IO is done.
That marking
Make the submissions in a systematic manner, Mr. Das,
Yes.
so that we'll have response of Mr. Kohli, then the things will become clearer.
Yes, my lord, what I'll do is, my lord, give a note to your lordship, which I prepared, so that your lordship will kindly go to the note when I address it tomorrow itself, my lord. I'll give a note.
If I may, lordship, for a moment, 3 things.
Yes.
One is, I personally apologize for the inconvenience to the bench. Number 2, lordship, if this note, I'm requesting Mr. Das, that note can be.
I'll of course pass it on to you. I'll of course pass it.
And third, lordship, I have another request, because what they are doing is they are bringing certain factual aspects which are not connected to the case. We'll need to respond. Like lordship asked the question on the 3 approvers, that I can easily answer, lordship. Now they are bringing in about employees of the APSC who were the touts. They were not probationers. They were confirmed employees working in the APSC. So if any of those points are there, I'm not.
No, he never referred to any employee of the APSC.
Mr.
APS.
Mishra, not Mr. Das.
He
Mr.
said
Mishra.
APS. No.
Assam Police.
Even Mr. Mishra didn't refer to any APSC.
No.
Lordship, Said Musharraf is of the APSC.
No, we are not referring to any
Said Musharraf. Mr. Mishra, did you refer to any Mr. Said Musharraf? No. There was no argument in reference to Said Musharraf. His entire argument is focused on principles of natural justice. That's all.
Yes, Lord. That I can easily satisfy, lordship.
Yes.
And on a police report.
Of course.
That's what I have to project before you.
And Mr. Kohli, one important thing which response we would require, that your associate here in Guwahati should bring out that gazette notification of this probation extension order. That should be shown to us tomorrow.
I'll speak with him.
Yes.
I'll ask Mr. Dipankar Nath to just take
Mr.
the
Nath,
detail.
yes. That gazette notification is paid to this writ appeal 333. That order is placed whereby the probation period was extended. This is at page 91. Similar orders, we are told that were passed for all the officers, whereby the probation period was extended after a gap, significant gap. So you will also have to answer the query that what was the status of the period in between.
They will continue to be, but I understand. I will answer that.
3 of the officers, 3 of the candidates where, my lord, they were made this, what you say?
Approver.
Approver, three candidates, I can give the name, so then. my
So that
learned friend-
name is already there on record.
Yes.
That is on record.
Yes.
Mr. Mishra pointed that out.
Yes.
Yes. So tomorrow, Mr.
Tomorrow
Das.
I'll give a note
Oh,
to
yes,
my
sure.
learned friend and to your lordship.
So Mr. Das will then start tomorrow morning, Mr. Das.
Yes, yes.
I've already started. I have given a
No.
little picture.
Arguments have been concluded by
Started.
Mr. Mishra appearing in so and so. Mr. Das commenced submissions in writ appeal number so and so. However, owing to paucity of time, the arguments could not be concluded. List for further hearing tomorrow.
Deeply obliged.
32, I will continue this case. My lord. Then
Pass forward.
it will. Sirji, are you-
Passover matter 70.
Deeply always.
Yes, Mr. Vort Pujari.
I beg apology that I was not present when I was in.
No
My lord.
You were to respond.
My lord.
What has happened?
Yes. My lord, the authorities have already undertaken an exercise that I.
So let we list it again on Thursday, next Tuesday. Give a copy to the petitioners council.
Yes, my lord, I will furnish it. Lordship will kindly accommodate me for 4 weeks because searching an alternative land will take some time, my lord. The authority.
Once we'll give you time,
My
once
lord.
come back on Tuesday. You know,
Tuesday.
list on Tuesday. as well.
My lord, my lord, my lord.
Okay. Done. Two matters more.
I am obliged.
Hearing. बाद में दे देना बात. Date दे.
With due permission of your lordships, reference will be made on passing away of late Dilip Kumar Hazarika, senior advocate, member of the Guwahati High Court Bar Association, and late Debabrata Banerjee, advocate, member of the Guwahati High Court Advocate Association. For order of reference, may I now call upon Mr. M.K. Chaudhary, President, Guwahati High Court Bar Association.
Honorable the Chief Justice, the other honorable judges of this honorable court, my respected seniors and colleagues in the bar, the members of the registry present. Today is a sad day for us. Late Dilip Kumar Hazarika, who was a senior advocate of this bar. Of course, he has left us at a matured age. But then the man he was and the love he was for everyone will be remembered by all. But then, since he was not in active practice for the last maybe a decade or so, many of the honorable judges may not have heard his argument, or many of the members of the bar also may not be familiar with the name or the person. He, besides being a senior advocate, he was a great actor. In fact, all of us must have heard that song sung by Lata Mangeshkar, Dil Hum Kare. The original Assamese song was filmed in 1963, Buku Hum Kare. There, That was a life of a martyr, Maniram Devan, who was hanged to death for 1857 uprising. Then this song was picturized on his picturized on him on Dilip Hazarika, and this has brought him to fame, although he was in the field of drama much earlier. Then thereafter, he had acted in important roles in many movies, and also he had been in the drama world, and also active in politics and social work. His loss is a great loss to the bar and also to the cultural society of Assam. I, on behalf of myself and on behalf of the Bar Association, pray to the God for eternal peace of the departed soul, and that the bereaved family members may be given the strength and courage to face these difficult days. So far as late Devabruta Banerjee is concerned, he was a banker, and after retirement in a successful career as a banker, he had joined this profession and did very well. He represented the many banks in the litigations, and I found him a very gentleman, out and out gentleman, and very soft spoken. And he died at a very early stage of 72. I, on behalf of the Bar Association, pray for the departed soul, that it rest in peace, eternal peace, and the bereaved members, I give my condolence.
Mr. Mahim Chandra Deka, President, Guwahati High Court Advocate Association.
Honorable Chief Justice of Guwahati High Court, Honorable other judges of the Guwahati High Court, respected President, Guwahati High Court Bar Association, respected Chairman, Bar Council of Assam, Nagaland, Mizoram, Arunachal Pradesh, and Sikkim, esteemed colleagues in the bar, respected members of the registry, we have assembled here today to condole the sad demise of two of our esteemed colleagues, Mr. Dilip Kumar Hazarika, Senior Advocate, Member of Guwahati High Court Bar Association, and Mr. Devabruta Banerjee, Member, Guwahati High Court Advocate Association. Mr. Dilip Kumar Hazarika, Senior Advocate, passed away on 14th September 2023 at 8:30 p.m. after protected illness at his Ujanbajar residence, Guwahati. He was 89 years old. Mr. Dilip Kumar Hazarika, popularly known as Okuda, was originally from Sibsagar in Upper Assam. He was born on 16th June 1934. After completion of his educational career, he enrolled as an advocate of Guwahati High Court and became a member of the Guwahati High Court Bar Association on 1st June 1965. The renowned lawyer was also a cultural activist, acted in films like Maniram Devan, among others, and played the role of Pioli Barua Martyr to its perfection. He was also involved in theaters and other cultural activities. He was a prominent writer, contributed articles on cinema, culture, and politics, known for their eloquence, insight, and intelligence. He was also associated with various democratic movements in Assam. On his death, we have missed a distinguished personality in Assam. He leaves behind a son and daughter. His wife predeceased him. Mr. Devabruta Banerjee was born on 6 November 1950 at Guwahati. He passed his SSLC and SS examination from Don Bosco School, Guwahati, and passed BSc degree examination from Arjavira College, Guwahati in the year 1971. Then he started his career by joining bank services and rose to the position of senior manager in United Bank of India. In course of service, he also continued his study and passed LLB examination in the year 1979 from JB Law College, Guwahati. After retirement from service on 31st October 2010, he enrolled himself as an advocate and practiced in the Honorable Guwahati High Court. From 19th January 2011. He also joined as a member of Guwahati High Court Advocate Association with effect from 1st July 2011 and became one of its life members. He involved himself in activities of the association and looked after the auditing works very efficiently for several years. He was also empaneled as an advocate of several banks. He was also involved in different socio-cultural organizations. He breathed his last on 3rd September 2023 at 3:30 p.m. at the age of about 72 years. He is survived by his wife, Mrs. Gauri Banerjee, 3 daughters, all are established, and the son, Mr. Devan Banerjee, who is an advocate of this honorable court. On the date of Mr. Devabrata Banerjee, we have lost a very active member of the association and an irreparable loss to his family members. On my behalf and on behalf of the Guwahati High Court Advocates Association, we convey our heartfelt condolences to all the bereaved family members of the 2 departed members and pray to the Almighty for their eternal peace.
Mr. Chinmoy Chaudhary, Chairman of Bar Council of Assam, Nagaland, Mizoram, Arunachal Pradesh, and Sikkim.
My Lord, the Honorable Chief Justice, the other judges of Guwahati High Court, the members of the registry, my esteemed colleagues in the bar. Lordship, in recent times, we have lost 2 of our members. One is quite senior, that is Dilip Kumar Hazarika, and the other member is Devabrata Banerjee. Mr. Dilip Kumar Hazarika was a member of the Guwahati High Court Bar Association, whereas Devabrata Banerjee was the member of Advocate Association Guwahati. Lordship, Dilip Kumar Hazarika is a senior member. He was designated senior since 1991. Born in 1934, he got enrolled as an advocate in 1962 and started his practice in Guwahati. Lordship, he was standing counsel for CBI and appeared in many cases during a period from 66, 67 onwards. And he appeared both in Guwahati High Court as well as in other courts on behalf of CBI. He was a versatile person with multifaceted activities in this career. And at the same time, he was an actor, a writer, a social activist. In 1983, he was a jury member in the committee for selection of National Filmfare Awardees. Lordship, he acted in many Assamese movies. One of them was Moniram Dewan, made on the life of a martyr, where he played an important role. And the famous song, Buku Hum Hum Kore, was put on his lips in the picture. Lordship, he took part in such activities like getting artists' welfare fund for the artist of the state with the fellow artist Abdul Majid. He was appearing in many dramas broadcasted by the All India Radio. That apart, he took part on stage activities appearing in many of the theaters and dramas. Lordship, at his demise, the bar has lost a eminent lawyer, a versatile person. The society has lost a matured artist of great talent. I, at his demise, on behalf of the Bar Council of Assam, Nagaland, Mizoram, Arunachal Pradesh, and Sikkim, as well as for myself, pray to the Almighty for eternal peace of the departed soul, and pray that Lordship, the Almighty may bestow enough strength on the members of the family to bear the loss. My Lord, Devabrata Banerjee was a person hailing from Rihabari, Guwahati. He belonged to a family who got settled in Guwahati long back, and he had studied in Don Bosco, where from he passed SSLC as well as HS exam. He passed his BSc in 1971 from IWW College, and thereafter he started study of law. And in 1979, he took his LLB degree and decided to join the bar. But after having graduation, Lordship, he was in United Bank of India, and through his adverse labor, he rose to the position of senior manager of the bank. After resigning, he joined the bar and practiced in various courts like the Tikobai Tribunal, etc., as well as in the Guwahati High Court. Mr. Banerjee had been suffering from cancer and was undergoing treatment at Delhi. And on 1st of September, the doctors attending informed the attendants that he was counting his last days and he better be taken to Guwahati, his home, because otherwise it will be difficult for them to take him back home. And immediately he was taken back home by air ambulance, and on 3rd of September, he passed away. He has left behind his wife, one son, and 3 daughters. His son is also an advocate now practicing in Guwahati. So, I pray to the Almighty for eternal peace of the departed soul, and also pray that Almighty showers enough strength to the members of the bereaved family to bear the extreme loss.
Mr. Dilip Mazumdar, Additional Advocate General, Assam.
Honorable Chief Justice, the other honorable judges of some court. Today, we have assembled here to mourn the death of two of the members of our legal fraternity. One of them being late Dilip Kumar Hajarika, a senior advocate, also popularly known as Okuda, who originally hailed from Sibsagar and has been and will always remain in the hearts of the people of Assam and beyond for his deep involvement in the socio-cultural activities, apart from being a member of our bar association. A noted writer, actor, film critic, and of course a veteran politician. Late Dilip Hajarika joined the bar in 1965 and was designated as a senior advocate in 1991 and was about 89 years of age at the time of his death on 14th of September 2023. He authored a number of books, to name a few: Ofuranto Pathabu, Kumai Porisu, Komar, Kurungot, Kuntu Dekilu, Kuntu Kunilu, etc. He acted in many Assamese films, and his proficiency in acting in a number of Assamese films was highly appreciated with special reference to the film Mandiram Dewan as Pioli Borua. He was also associated with historic Kumar Bhaskar Naitya Mandir of Ujan Bajar, Guwahati. He is survived by his son and daughter while his wife predeceased him. The other member of our fraternity who also left us for his heavenly abode is Debabrata Banerjee, who was a banker, and while in service, he completed his last law degree from JB Law College, Guwahati. In January 2011, he enrolled himself as an advocate after his retirement from service in the bank. Ever since then, he has been practicing before the Assembly Court, becoming a member of Guwahati High Court Advocates Association with all the seriousness. And in addition to pursuing his legal profession, he served the association with utmost sincerity, which was duly recognized by the members of the association. He is survived by his wife, 3 daughters, and a son who has become a lawyer here. I, on behalf of myself and on behalf of the state of Assam, offer deep condolences to the bereaved family and sincerely pray for the eternal peace of the departed souls.
Mr. B.D. Goswami, Additional Advocate General, Arunachal Pradesh.
Honorable Chief Justice, other honorable judges of this High Court, respected members of the registry, respected senior members of the bar, my colleagues, and ladies and gentlemen present here. This indeed is another unfortunate occasion, as we have congregated to mourn the sudden demise of 2 of our dear colleagues in the bar who left us for the heavenly abode during the recent past. The first name that comes to mind is that of Dilip Kumar Hajarika, senior advocate, who breathed his last on 14 September 2023 around 8:31 p.m. at the age of 89 years at his own residence in Ujan Bajar, Guwahati. Senior advocate Hajarika was born on 16/6/1934 in Hyohagor, and he joined in this bar on 1st of January 1965 after his enrollment in 1962, and was designated as senior advocate of this bar on 13th of August 1991. Having a good practice in all branches of law, including civil, criminal, constitutional in this High Court, as well as its subordinate courts, he was a very busy lawyer during his time. He also served as the senior standing counsel for Central Bureau of Investigation for several years. Senior advocate Hajarika had an incredible personality and was a man for all occasions. With flowing hairs and a smiling face, his presence brightened up wherever he went. Very witty and with a good sense of humor, Senior advocate Hajarika left an indelible mark upon anyone coming in contact with him. In addition to his legal profession, Senior advocate Hajarika was a noted actor, film critic, writer, and a veteran politician from Assam. He also performed the role of Pioli Borua in the film Maniram Dewan. Contributed to the Assamese literature through his literary works, and he was a writer who had many books to his name. Some of his books in Assamese are Ofuranta Kothabur, Humai Purisu Homoyor Hurongot, Kuntu Dekhilu, Kuntu Hunilu, and many more. And he wrote several articles on cinema, culture, and politics in Assamese dailies like Aji, Notun Homo, and Ohomia Protidin. Senior advocate Hajarika was also associated with various democratic movements in Assam and was also an active member of Congress as party for some time. He was an integral part of the historic Kumar Bhaskar Naitya Mandir, Ujan Bazar, for 6 decades, that is from 1950 to 2010. Apart from being associated with other socio-cultural organizations, he was also a member of jury from India in Film Festival and represented the country in peace missions abroad. The demise of Senior advocate Hajarika is not only a great loss to the fraternity, but is also no less a loss to the socio-cultural field of Assam. On his death, Senior advocate Hajarika has left behind his son, namely Sriman Prayagraj, and daughter Srimati Priyadarshini, and many more relatives and well-wishers. The wife of the Senior advocate Hajarika predeceased him. Another loss to the fraternity is that of advocate Debabrata Banerjee, who died on 3rd of September 2023. Prior to joining in this profession, he worked in United Bank of India. Having good knowledge in banking law, advocate Banerjee did his practice in both civil and criminal sides and before this Guwahati High Court and its subordinate courts. Advocate Banerjee was also in the panel of Legal Aid Council of the Honorable Guwahati High Court. He was a life member of the Guwahati High Court Advocates Association, and he took care of the accounting works of the association efficiently for several years. Even if I haven't had the opportunity of knowing him personally, I have been told that Advocate Banerjee had a very amiable disposition. Advocate Banerjee has left behind his wife and 4 children, including his son Sri Dipayan Banerjee, who is an advocate of this Honorable High Court. I, on behalf of the state of Arunachal Pradesh and its people, and also on my personal behalf, offer our sincere condolences to the bereaved families of our said deceased colleagues and pray to God for eternal peace of the departed soul.
Mr. Anjan Kalita, Additional Advocate General, Mizoram.
Honorable Chief Justice of the Guwahati High Court, Honorable Judges of the Guwahati High Court, members and officers of the registry, my senior colleagues, and my friends in the bar. We have assembled today on the said to mourn the said demise of two of the members of our legal fraternity. One is Dilip Kumar Hazarika, a senior advocate. Another one is Mr. Debabrata Banerjee, who was a banker, retired. After retirement, he has joined the legal profession. As far as Dilip Kumar Hazarika is concerned, he was an illustrious member of the Guwahati High Court Bar, who has left for his heavenly abode on 14/9/2023 at the age of 89 years. He has been suffering from various old age related ailments for some time and waited his last in the Ujan Bazaar residence. His wife had preceded him, and he left behind his one son and one daughter. A veteran actor, a social cultural activist, a writer, and a lawyer, all put into one, late Dilip Kumar Hazarika was a multifaceted personality. He was a humble person with an amiable nature, loved by everybody who comes across him. Late Hazarika was born on 16/6/1934 in a well-known Hazarika family of Sibsagar. His father, late Pitambar Hazarika, was also a known lawyer in Sibsagar. From a very early stage, late Hazarika was attracted to various cultural activities and involved in theatre largely. He was closely associated with historic Kumar Bhaskar Natya Mandir in Guwahati's Ujan Bazaar, where he dedicated almost 6 decades of his life in the theatre movement and other cultural activities. As a writer, he used to regularly contribute articles to daily newspapers as well as periodical magazines. He had penned many books too. His book titled Ofuranto Othabur has been very popular since its publication. He has acted in numerous Assamese movies. He shall be always remembered for his portrayal of a revolutionary Purely Borua in the iconic Assamese film Moniram Dewan. Late Hazarika was equally good as a lawyer, and he had been designated with senior advocate by the Honorable Guwahati High Court in 1991. He enrolled himself as a lawyer in the year 1962 and went on to practice for more than 4 decades. His passing away is a great loss to the bar, as well as to the cultural field of Assam. On his death, we convey our sympathies and gratitude to the bereaved family and pray to the Almighty to give strength to the family to bear this enormous loss. Debabrata Banerjee, who was working with the United Bank of India, after his retirement, he has joined this profession of law. He represented many banks in the Honorable Guwahati High Court. He died at the age of 70 years, leaving behind his wife and 3 children, including 1 advocate son. I, on behalf of the state of Mizoram, as well as on my personal behalf, condole the passing away of Dilip Kumar Hazarika and Debabrata Banerjee, and I pray to the Almighty for eternal peace of the departed souls.
Mr. Ranjit Kumar Deb Chaudhary, Deputy HGA.
Honorable the Chief Justice, Guwahati High Court,
honorable judges present here today, members of the registry, learned senior advocates, and my colleagues in the bar. We assemble here today to mourn the death of two of our colleagues, late Dilip Kumar Hazarika, senior advocate and a member of the Guwahati High Court Bar Association, and late Debabrata Banerjee, advocate and member of the Guwahati High Court Advocates Association. Dilip Kumar Hazarika, as my predecessor speakers have pointed out, was a multifaceted personality. Although by the time that we have joined, he was not in active practice. But I am told that he had represented the CBI and other organizations, and he had a very flourishing practice. I joined in 1998. But at that point of time, though I did not see him argue a case, but he was always present in the court. And everybody would agree that he was a very loving personality. Any query, he is always ready with an answer. And he has been immortalized. His personality has been immortalized by his portrayal in the film Moniram Devan and the song Buku Hum Hum Kore. That song picturized on him would be there in the minds of all for many years to come. Late Debabrata Banerjee was a banker. I had come in contact with him about 10-12 years back in another function. Of course, at that point of time, I did not know that he had taken up the profession of advocacy. A person with positive vibes, and he would have always pushed me to do better. His experience in life, he has always shared. I pray to God to give strength to the Almighty. I pray to God to give strength to the family of the departed soul to bear with this loss.
Ms. M. Kechi, Additional Advocate General, Nagaland.
My Lord Chief Justice, Honorable Judges, member of the registry, learned senior advocates, and my dear colleagues of this esteemed bar. I stand here today to offer my condolences on the passing away of late Dilip Kumar Hazarika, senior advocate, who expired at the age of 89 years, and late Debabrata Banerjee, who expired at the age of 72 years. Late Mr. Dilip Kumar Hazarika was a designated senior advocate who joined the Bar Council on 25/9/1962, and after a protracted illness passed away on 14/9/23. Late Mr. Hazarika was an actor and was involved in theater and other cultural activities. He leaves behind a son and a daughter. Late Mr. Debabrata Banerjee was a life member of the Guwahati High Court Advocates Association and was actively involved in the activities of the association. As an ex-employee of the United Bank of India, Mr. Banerjee overlooked after the auditing works of the association and was also an empaneled advocate of several banks. Late Banerjee leaves behind his wife, 3 daughters, and a son who is a practicing advocate of this Honorable High Court. I express my grief on the demise of 2 of our esteemed advocates, and today on my personal behalf and on behalf of the government of Nagaland and the people of Nagaland, express my heartfelt condolences to the bereaved and grieving family. May their soul rest in peace.
Now may we have the honor of reference by Honorable the Chief Justice.
My esteemed brother and sister judges on the bench, Mr. M.K. Chaudhary, President, Guwahati High Court Bar Association, Mr. Mahim Chandra Deka, President, Guwahati High Court Advocates Association, Mr. Chinmoy Chaudhary, Chairman of Bar Council of Assam, Nagaland, Mizoram, Arunachal Pradesh and Sikkim, Mr. Dilip Mazumdar, Additional Advocate General Assam, Mr. B.D. Goswami, Additional Advocate General Arunachal Pradesh, Mr. Anjan Kalita, Additional Advocate General Mizoram, Mr. R.K. Dev Chaudhary, Deputy Solicitor General of India, Miss M. Kechi, Additional Advocate General, Nagaland. Family members of the late advocates, then senior advocates, members of the bar, members of the registry, judicial officers. Today, we have assembled here to mourn the sad demise of late Sri Dilip Kumar Hazarika, senior advocate, member of the Guwahati High Court Bar Association, and late Sri Devabrat Banerjee, advocate, member of the Guwahati High Court Advocates Association. Late Sri Dilip Kumar Hazarika was born on 16th of June 1934. He enrolled himself as an advocate in the year 1962 and eventually joined the Guwahati High Court Bar Association in the year 1965. Late Sri Hazarika was a man of multifaceted personalities. He has left his indelible mark in the annals of legal profession as well as in the socio-cultural field. He was widely known and respected for his contribution in the field of theatre and other cultural activities. He was well known for his role in the movie Mani Ram Devan. He was a prolific writer and has authored many books. He was designated as a senior advocate in the year 1991 in recognition of his invaluable contribution in the field of law as an advocate. He breathed his last on 14/9/23, leaving behind his son and daughter. Late Sri Devabrat Banerjee was born on 6th November 1950 in Guwahati. He did his schooling from Don Bosco School, Guwahati, and graduation from the Arya Vidya Peeth College, Guwahati. He obtained his LLB degree from the JB Law College in the year 1979. Thereafter, he joined the banking sector and became the senior manager of the Union Bank of India before his retirement. After his retirement from service in the year 2010, he enrolled as an advocate and joined the Guwahati High Court Advocates Association on 1/7/2011. He actively involved himself in the activities of the association as one of its life members. His wide experience in the banking sector enabled him to be empaneled as an advocate of several banks. He was also involved in activities of various socio-cultural organizations. Sri Devabrat Banerjee breathed his last on 3rd September 23, leaving behind his wife, 3 daughters, and a son who is a practicing advocate of this court. I did not have the opportunity to meet the learned advocates personally, but I am told that they were respected by all for their gentle behavior, amiable disposition, and fair submissions in the court. Their contributions in the legal as well as the socio-cultural fields will continue to inspire the legal fraternity and the society at large. Their death is a great loss, not only to their families, but also to the legal fraternity and the socio-cultural world. I and my brother and sister judges on the bench fully associate with the sentiments and feelings expressed by the members of the bar. I, on behalf of my esteemed colleagues on the bench, the members of the registry, and my own behalf, convey heartfelt condolence to the members of the bereaved families and pray to the Almighty God to grant eternal peace to the departed souls and give sufficient strength and fortitude to the family members to bear the irreparable loss. As a mark of respect to the departed soul, I request the learned members of the bar and bench to observe a minute's silence. Judicial work in the courts will remain suspended for the rest of the day as a mark of respect to the departed souls.